If there is any prayer for listing, please give it to the court master. Yes,
Lordship, item number 10, Lordship.
10.
Lordship. This case, Lordship, Lordship may not like to take up the matter because earlier, Lordship. The issue is of 12 or 13, Lordship.
Pardon me?
Not by Lordship.
Okay. Raise this matter before any other bench without me.
Lordship.
Okay.
Lordship was earlier.
Okay.
Earlier consulted Lordship. The issues are of 12, 13, Lordship.
Okay, whatever be, I don't remember. Okay.
Wait, please, my lord. Beg to mention for requisition, we have filed one IA in item number 8, my lord. I am for the petitioner. It may kindly be allowed, my lord, requisition. Item 8 of today's daily list, my lord.
Item 8.
8.
There's no IA here.
My lord, we have filed it yesterday, my lord.
Okay.
Prayer for requisition, my lord.
No, it will not come by requisition. There will be a listing if it is IA.
My lord,
Give it to the court master. It has to be listed. It can't come on requisition.
my lord,
Yes.
I beg to mention for listing of a petition in admission column.
Give it to the court master.
My lord, may it please, my lord. Item number 8 of today's daily list, I seek adjournment for the day. The conducting counsel for the respondent, he is suffering from certain health issues. Cannot conduct the case.
Okay. You have taken consent of the other side.
Consent, my lord, not taken.
You don't know anything called consent.
My lord, consent,
No. Without consent, don't make a prayer in the court. No. Let the matter reach, then you make a prayer.
Daily list item number 1, 2, 3 for admission.
Made please, your lordship. Am I item number 2?
Yes.
Made please.
Here is the main particular.
And let me start, you please call me. Well, what had happened in this case? The cadre strength of stenographer grade 1 in the Assam Secretariat is, my lord, 65. And 40% being 26 is the promotional quota. And my lord, 39 is the direct recruitment quota.
Just 65 is the strength.
Strength. 40% of 65, that is 26, is the promotional quota.
45 promotional quota.
40%.
40.
So it comes to 26.
Yes.
Now, my lord, we are concerned with the promotional quota, so we are not concerned with the direct recruit quota. Now, my lord, out of this 26, 16 who are senior to us and who has got the required qualification, my lord, they have been promoted from grade 2 to grade 1. Now, my lord, for now, there are about 14 vacancies to be filled up.
Yes.
Now, my lord, I am otherwise within the zone of consideration. I have got the required qualification. I am not being promoted. And my person who do not have the qualification, now they are sought to be promoted. In other words, my lord, there is a requirement of having, my lord, graduation. Now, before I take your lordship to the other facts, if your lordship would kindly take the rules, a copy is already handed over on the last page. If your lordship would kindly have the yellow flag, my lord. My lord, 15th of February 96.
Just a moment. Just a moment. Because the respondent number 3, they have taken a stand that the educational qualification was relaxed.
My lord, lordship knows if a matter is governed by 309 rules, executive instruction cannot override. That's the law.
That is the only point.
Yes.
That is the only point
Yes,
involved
my
here.
lord. My lord will kindly take the rules, my lord.
Yes,
Yes.
but power to relax is always there.
My lord.
Normally, the power to relax is always there.
No, but you cannot relax
Essential-
by way of an executive instruction.
Yes,
No, my lord, essential rules of recruitment cannot be relaxed. What can be relaxed is condition of service. So essential qualification that cannot be relaxed. Please come to page 25 of the rule, my lord. A recruitment to various cadres in service shall be made in the manner prescribed hereinafter. Namely, please come to 3, my lord, stenographer grade 1. By recruitment in accordance with Rule 6 and Schedule 1, Part B.
yes,
Then my lord will kindly come to 4. Stenographer grade 2. By recruitment in accordance with Rule 6, Schedule 1, Part B. Now, very pertinently, please come to 5. Stenographer grade 3. By direct recruitment in accordance with provisions of Rule 6, Schedule 1, Part A. That means, my lord, entry level is grade 3. There it is direct recruitment. Then beyond that, it is promotion. Then please come to Rule 6, my lord. Appointment to the cadre of stenographer grade 3 shall be made by direct recruitment, and cadre of stenographer grade 2 and stenographer grade 1 shall be filled up by recruitment in accordance with the procedure as provided in this rule. For appointment to stenographer grade 1 from stenographer grade 2, one should complete 6 years of continuous service in either or both the cadre of stenographer and or in the grade 3. Then my lord will kindly come to page 28. Rule 8. The academic qualification of candidate for appointment to each cadre shall be prescribed by the government from time to time. The qualification and experience prescribed as on the date of commencement of these rules are given in Schedule 1, Part A and B. So, Lordships will get the qualification in Schedule 1, Part A and B. For that, my lord will kindly come to page 37. Page 37, Schedule 1, Part B. The minimum qualification.
yes, I'm there.
Yes. The minimum qualification and experience for recruitment to the cadres of service shall be prescribed below. Stenographer grade 1, pass degree examination or equivalent examination from a recognized university. Similarly, if your lordship would kindly come to 2, stenographer grade 2 passed the degree examination or equivalent examination from an recognized university. So therefore, my lord, degree is an essential qualification. And my lord, this rule was amended. That amended rule lordships will get at page number 30 of the writ petition. Amendment of Rule 5.
At one point of time, the earlier stenographers who were excellent in their work in our court, they all had LLB degrees.
Huh.
Because it became easier for them to take the dictation. They understand what is going
Yes,
on,
yes,
what is being
yes.
transpired in the court.
For a normal, and moreover, my lord, the one who is attached to the honorable judges and one who works in this is a sea of difference. There are hardly, my lord, small things. Here it runs into hundreds of pages. So they cannot cope up with the work here. Because their job is very limited, one letter or maybe some note. Please come to page 30, my lord, section 2 of the amending act, where amendment of rule 5. For existing sub rule 3, the following shall be substituted, namely stenographer grade 1 by direct recruitment up to 60% in accordance with provisions of rule 6, schedule 1 and 3, and by promotion up to 40% in accordance with rule 12 from the select list of stenographer of grade 2 who have completed 6 years of continuous service in the post of stenographer grade 2 in respective office and pass degree examination from a recognized university. So, my lord, therefore, the stipulation or rather the prescription is very clear. Now, my lord will kindly come to page number 35.
Page,
My lord, page number 35. My
yes.
lord, this is a writ petition listed as item number 2. Now, these are the person who are not graduates. Now, kindly see, my lord, what is the projection by them. Please come to para 18 at page number 49. That the petitioners state that ignoring the above mentioned development as stated above, the Commissioner and Secretary to the Government of Assam, Secretariat Administration Department, published Gazette notification dated 27/10/20, amending the Assam Stenographer Service Rule 95 without condoning the educational qualification for the post of stenographer grade 1 from stenographer grade 2 and stenographer grade 2 from stenographer grade 3 by way of promotion. The petitioners who are now serving as stenographer grade 2 completed more than 7 years of continuous service in the post of stenographer grade 2, have otherwise qualified for the post of stenographer grade 1, except qualification clause 5(3) of the rules of 2020. My lord, a projection is sought to be made as if the requirement of graduation is for the first time being insisted upon in the amended rules. The 1995 rule itself says so. So this is the projection. Now, my lord will kindly come to the prayer. Is this prayer even conceivable, my lord? We don't challenge the virus of the rules. Please come to the prayer at page 52.
Just
issue
a
a
moment,
read in
just
the-
a moment.
I'm
just a
sorry,
moment.
madam.
No,
So in para 18, they are trying to project that for the first time, the graduation requirement was envisaged in 2020 amendment, which is not correct. As that's why I placed the rules at the very outset.
yes,
My lord will kindly come to 52, page 52, prayer. To issue a writ in the nature of mandamus directing respondent authorities to condone the educational qualification as mandated for the post of stenographer grade 1, as was done in their earlier cases while continuing their recruitment to the cadre of stenographer grade 2 from the stenographer grade 3 and to deem the petitioners to be eligible for promotion. Like even if a wrong was made, that cannot be perpetuated. Article 14 is a positive concept, my lord. So, my lord, this is the position. Then, my lord, kindly have a look at the order which was passed in the writ petition at page 57. Third, UK Nair Learned Senior Counsel representing the petitioners, assisted by Khonikor, Also heard SS Roy Learned Council for respondent number 1 and H. Alia Learned Council except notice of so and so. Issue notice. Then my lord will kindly come to the last para. It is ordered that if any promotions are made to the post of stenographer grade 1 under Secretariat Administration Department, the same shall be subject to outcome of the present writ petition. Also, in the event any promotion orders are issued, the same would reflect the pendency of the present proceeding.
Yes.
Now, please come to page 59, my lord. Now, I have already indicated, my lord, the 16 who were senior above, my lord, the petitioner, they were promoted. And in the order, it was indicated also that promotion will be subject to outcome of this case. Page 59.
Yes.
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 Yes. So, my lord, 16 were senior to us. They were
This
promoted.
AC is not properly working. I am feeling suffocated. So that's why I am being
Because
distracted.
we also went downstairs, my lord. That is also another reason.
Perhaps. And that's why I'm being distracted.
Right, right. And it's too hot also, my lord. Humidity is really high. I think Lordship has noticed page 59, my lord. Now please come to page 60. Now please come to, my lord, Roman 2 vacancy. 14 at
What
present,
is this page 60 is what?
60, my lord.
No, it is what? What is this document?
This is a note, my lord, agenda note.
Okay.
My lord, the agenda note is prepared prior to, my lord, the DPC.
Yes.
So this is the note. Now they say at present there are 12 existing vacancies and 2, my lord, anticipated vacancies. In all, it is 4. Therefore, 14 vacancies are to be filled up. Now, please come to, my lord, Roman 5. We are not concerned with those backlog and all. There is no dispute on those counts. As per Rule 5.3 of the Assam Stenographer Service Rule 1995, all stenographer grade 2 who have completed 6 years of continuous service in the post of stenographer grade 2 and passed degree examination from recognized university shall be eligible for promotion to the post of stenographer grade 1. So this is how, my lord, this is the persons who are shown. If your lordship will kindly come to page 61, serial number 13 is the petitioner, my lord, who is a graduate, and my lord, he has already put in 8 years of service. More than 8 years.
Serial number 12.
Serial number 13, my lord.
13.
E. Raghumani Singha.
Yes.
Now kindly come to, my lord, page 62. This is the DPC minutes. Minutes of the meeting of the selection board held on 17th of March 22 at so in the office chamber of the Chief Secretary Assam for promotion to the cadre of senior special officer, etc., etc., etc. Now, the operative portion of the minutes is at page 63. The member secretary apprised the selection board that Jitu Kumar Soikia and 9 others submitted writ petition before the High Court by WPC number so and so for promotion by confirming of their educational qualification. An honorable court in its order dated 9/12/20 directed that if any promotions are made to the post of stenographer, the same shall be subject to outcome of the present writ petition. Also, in the event any promotion orders are issued, same would reflect the pendency of the present writ petition, that is 516/2020. After examination of the court order and considering other aspects, the selection board advised department to move for one-time relaxation of educational qualification in respect of undergraduate incumbents in both cadres of stenographer grade 2 and grade 3 to make them eligible for promotion to the next higher cadre. Till then, selection board decided to defer recommendation of DPC to fill up the vacancy of the stenographer grade 1 and grade 2 by way of promotion. My lord, what business selection board has got, my lord? And see, my lord. So this is how, my lord, along with the ineligible, my lord, the eligible are ones are, my lord, suffering. Therefore, my small prayer is, my lord, without going into the merits of the case.
Ineligibles are made eligible.
Now they are sought to be made. Unequals are sought to be treated equal. Now, my lord, this is where the matter stands. That's why I am before your lordships. At least, my lord, in the other case, they have done it. The 16, that there they have said. Here also you can say it will be subject to the outcome of the case. And my lord, is it an enforceable right to seek condonation of educational qualification? Is it an enforceable right? Which court of law will say condone the, my lord, required educational qualification? This is the case. Therefore, my humble submission is, my lord, lordship should give an immediate direction. They should proceed with the DPC, should go ahead with their selection. Whosoever now eligible in the zone of control, let their cases be considered. And the other aspects, the other writ petitions, if they succeed, they're different thing. Otherwise, my lord, they cannot get promotion from either grade 3 to grade 2 or from grade 2 to grade 1. So they come to High Court with a projection as if, my lord, the prescription of graduation came for the first time in the amendment. From the 95 rule itself, it says, my lord, it is required. This is the case. Well, I'll just leave a little more clarifications, my lord. My lord, can I place 2-3 judgments, my lord? Now, my lord, or if your lordship will kindly take the additional affidavit, my lord, dated 9/6/22. The
Yes.
factual part I must complete. Memorandum of কি আছে না? মারেন না, এটা department আছে।
Yes.
Yes. Please come to, my lord, page 6. Or 6 to the number. Internal 6 on there. Running page will be, my lord, page 70.
Yes.
Now, this is a cabinet memorandum, my lord, to be circulated under Rule 17 of the Assam Executive Business. Relaxation of educational qualification in respect of stenographers grade 3 and grade 2 who are otherwise eligible for promotion to the post of stenographer grade 2 and grade 1 of Assam Secretariat. My lord, this General Secretariat Administration Department, in so many cases I have seen, they are so finicky, my lord, about all this. I do not know why in this case they have taken this liberal stand, my lord. In fact, I am fighting a litigation on behalf of a person who got a job under the Assam Accord, my lord. Now, initially he was to be appointed in terms of that the rule which was framed by the state. He was given ad hoc appointment, then he was regularized. Now, for their fault, my lord, personnel department says, when you appointed him as an ad hoc, that you committed a wrong, that was not their mistake. Now, because you regularized him subsequently, how come you are counting his seniority from later date? That litigation, tomorrow it is coming up before court number 1. Where, my lord, this General Administration Department is so finicky, my lord. They are, I mean, as if, my lord, they don't bunch any inch also. Now, in this case, we are seeing what they are doing, my lord. Now this এখন কি হলো ultimately pass হল ফালতু নয়
Maybe the authorities are living like judges. Because except for my secretary,
yes
I have access to no one.
my lord will kindly come to then we challenge the writ petition we file this writ petition my lord if your lordship will kindly come to number 72 and operative portion is at 74. Heard Sri Swenso, learned senior counsel for the petitioner who submits that promotion to the post of stenographer grade 1 and stenographer grade 2 requires candidate to be a graduate. Private respondents 5 to 13 are not graduate and accordingly cannot be promoted to the stenographer grade 1. He submits that in view of the innocuous order dated 9/12/20 passed in WPC, state respondents have misinterpreted the said order and have taken steps to relax the educational qualification required for promotion of the private respondents, wherein there would be relaxation of the recruitment rules pertaining to educational qualification required, that is graduate degree, for the purpose of promotion to the stenographer grade 1. The petitioner's case is that the petitioner is a graduate having more than 32 years of service as a stenographer and is eligible to be considered for promotion to the stenographer grade 1. However, due to illegal proposed action of the state respondents in trying to relax the educational qualification for promotion of the private respondents, and illegality is going to be committed. And my lord, all these decisions are cited. Then my lord, last subpara, in view of the law laid down by the apex court in Nagarajana, and my lord, wherein it is held that executive instruction cannot supersede rules made under proviso to Article 309 of the Constitution, and keeping in view the judgment of the apex court in case of Keshav Chandra Joshi, this court is of the view that relaxation of Rule 5.3 of the rules as amended into 2020 to enable private respondents to be considered for promotion to the stenographer grade 1 should not be given effect to till the next returnable date. So my lord, this order was extended. And the interim order was dated 1/6/22, my lord. And on the same day, my lord, perhaps backdated, my lord, they said required page 77, required educational qualification of passing degree examination from a recognized university in respect of the following stenographers for promotion to the post of stenographer is hereby relaxed by invoking Rule 25 of the Assam Stenographer Service Rule 95. My lord, this cannot be done, my lord. It's a settled law. First, my lord will kindly come to. My lord will kindly have this 1992 3 Supply 3 SCC 575.
Just a moment.
Keshav Syed Khalid Rizvi, my lord. 1993 Supply 3 SCC 575, paragraph 33.
This notification at page 77,
Yes,
has it been sealed?
yes, yes. My lord, because it was by way of this additional affidavit we brought on record and we have assailed also. Originally, my lord, it could not be done because it was after filing of the writ petition, this came to light because interim order was also passed on the same day and the notification was also issued on the same day.
But there may be a technical argument that in fact the writ petition was not amended to
My lord,
incorporate that.
Lordship will kindly appreciate one thing. 226 proceedings, my lord, I think once illegalities are brought to your lordship, had it been a case, we also would not have brought in by way of an amendment. Then, by way of the additional affidavit, then things would have been different. Purpose of filing the prayer for discipline. In fact, my lord, if your lordships will kindly have that pleadings, my lord. If your lordship will kindly come to page 66, my lord. Page 66. My lord, in form it may not be there, but in substance the pleadings are there.
Yes.
Para 1, that the present affidavit has been filed by the petitioner to bring on record certain developments which came to the notice of the petitioner pursuant to the filing of the WPC number so and so. In the humble understanding of the petitioner, such development have a relevant bearing, proper adjudication of the issues involved in the present case. As such, the petitioner respectfully prays that this honorable court may be pleased to treat the statements made in this affidavit as a part of pleadings made in the WPC number so and so. Please come to para 3, my lord. Para 3, that the state authorities in a most illegal and arbitrary manner have mooted a proposal to promote the respondents number 5 to 13 who are not graduates to the post of stenographer grade 1 from stenographer grade 2. Such action amounts to relaxing conditions of recruitment, which is not permissible in the IF law. Unfortunately, the cabinet to the government of Assam in its meeting approved the said proposal for relaxation of educational qualification of respondents number 5 to 13. The petitioner could not get hold of the cabinet document from another writ petition filed before the court by a similarly situated person. That being highly aggrieved with the aforesaid relaxation of the undergraduate stenographer grade 2 for promotion to stenographer grade 1, writ petitioner approached this honorable court by the present writ petition, assailing the legality and validity of the impugned order. Then please come to paragraph 6, my lord, that it is humbly brought to the notice of this honorable court that learned departmental counsel was present. An interim order dated 1/6/22 was passed by this honorable court. Be that as it may, petitioner came across a notification dated so and so, issued by the Commissioner and Secretary to the Government of Assam, whereby it has been notified that required educational qualification of passing degree examination from recognized university for promotion to the stenographer grade 1 has been relaxed in respect of the respondent number 5 to 13. That it is humbly submitted that the impugned notification is in clear violation of the law laid down by the apex court in so and so, wherein it has been held that executive instructions cannot supersede the rules made under proviso. Further, it is on no longer recidigra that conditions of recruitment cannot be relaxed. The said proposition of law finds favor with the Honorable Apex Court in a decided a decision rendered in Keshav Joshi versus so and so. As such, the impugned cabinet memorandum dated and notification dated being legally unsustainable warrants interference at the hands of this court. So, my lord, there are, as I submitted, my lord, in form it may not be there, but in substance it is there. And we have also filed an IA also. This is pending. Now, my lord, we kindly come to the decision, my lord. Similar relaxation rule was, my lord, an issue in this case, 1993, Supply 3 SCC, is 575, para 33. My lord, these relaxation powers are given to be used in public interest. It can't be used to, my lord, favor somebody. Some underqualified persons are sought to be favored. For that, certainly relaxation power do not exist, my lord. It can't be that it is in administrative efficiency either. Rule 3 of the residuary rule provides the power to relax rules and regulation in certain cases. Where central government is satisfied that operation of any rule made or deemed to have been made under Act, any regulation made under any such rule, regulating condition of service of persons appointed to All India service cause undue hardship in any particular case, it may by order dispense with or relax the requirement of the rule or regulation. Kindly see, my lord, regulating condition of service, not rules of recruitment.
What are the SEC paragraphs?
33, my lord. May I read it like that? Para 33. The sentence starting with the rule 3 of the residuary rule provides.
Yes.
Yes. Rule 3 of the residuary rule provides the power to relax rules and regulations in certain cases. Whereas central government is satisfied that operation of any rule made or deemed to have been made under the Act or any regulation made under any such rule regulating, kindly mark the word, conditions of service of persons appointed to All India service cause undue hardship in any particular case, it may by order dispense with or relax the requirement of the rules or regulation as the case may be to such an extent and subject to such exception and condition as it may consider necessary for dealing with the case in a just and equitable manner. Rule 3 empowers central government to relieve undue hardship caused due to unforeseen or unmerited circumstances. The central government must be satisfied that operation of the rule or regulation brought about undue hardship to an officer. The condition precedent, therefore, is that there should be an appointment to the service in accordance with the rules, and by operation of the rule, undue hardship has been caused, that too in an individual case. The central government, on the satisfaction of those conditions, have been empowered to relieve such undue hardship by exercising the power to relax the norm. Now, this is important. It is already held that conditions of recruitment and conditions of service are distinct, and later is preceded by an appointment according to rules. The former cannot be relaxed. The latter too must be in writing, that too with the consultation of UPS. So I am on this, my lord. So in service jurisprudence, my lord, there is a clear-cut distinction between condition of service and rules of recruitment. What can be relaxed is condition of service. Otherwise, my lord, an ineligible person, so then, my lord, supposing a post is advertised that requiring that graduate, my lord, undergraduate applies and applies for relaxation, how? Doesn't stand to any logic, my lord. So this is the, in my humble submission, is the settled position, my lord. It has been followed in subsequent decisions. Yes. Then, if your lordship would kindly take the other decision, my lord. 1979, 4 SCC 507. Nineteen 4 SCC 507. Para 25.
Just a moment.
Yes. '79 4 SCC 507.
Yes.
My lord, the para 25, it starts with apart from repelling the contention. Para 25.
Apart from repelling,
Yes.
yes.
Apart from repelling the contention that regularization connotes permanent, these observations furnish the second reason for rejection of the argument advanced on behalf of the promotee. And that reason is that when rules framed under Article 309 of the Constitution are in force, no regularization is permissible in exercise of the executive power of the government under Article 162 thereof in contravention of the rule. Now, Lordship may kindly skip that. Kindly come to the later part of para 25, my lord. The last 4 lines, starting with what could not be done. What could not be done, has your lordship.
Yes.
What could not be done under the 3 set of rules as they stood would thus be achieved by an executive fate. And such a course is not permissible because an act done in exercise of executive power of the government, as already stated, cannot override the rules framed under Article 309 of the Constitution. So, my lord, the rules of 1995 prescribes graduation as one of the, my lord, qualifying criteria. Now, that is a condition of recruitment. Number 1, it cannot be relaxed. Number 2, my lord, since the prescription is under a rule framed under 309, therefore, my lord, by an executive exercise of power, you cannot override that. So from whatever viewpoint, my lord, you view at it, the order, end of the matter is, end of the day, is unlawful, my lord, is untenable. Therefore, my lord, having regard to the legal position that emerges and the factual background, in my humble submission, my lord, there cannot be any question of relaxing the conditions of recruitment. And in fact, my lord, they have not come to court with clean hands. When in para 18, they say that amendment introduced that requirement, that is again a wrong statement, my lord. Rather a false statement or note. Therefore, my humble submission is, my lord, as the DPC has already promoted 16, my lord, with the rider that it will be subject to outcome of this case, they should also, my lord, convene the DPC immediately and consider the case of those who are eligible, those who are having the educational qualification. And for not doing all these things, my lord, we are being prejudiced, my lord. So therefore, this is my humble submission, my lord. So therefore, my lord, the writ petition filed by the other side, I don't think it, I don't know, it will be too much, my lord, to come file a writ petition and make a prayer that you condone the educational requirement. I don't think, my lord, if they would have challenged the virus of the rules, that also, my lord, where is the possibility? So what you cannot do directly, you cannot do indirectly. That is my humble submission. With the lordship's kind permission, can I leave you?
In other cases, madam, that is 5/62, madam. I am appearing that. Item number 2,
Hmm.
5/62. Whereas the petitioner seeking for condonation of their educational qualification. Initially, the petitioners are appointed as a stenographer for gate 3. By way of condoning the educational qualification, they are promoted to gate 2. So it is not a case that, before amending the 2020 rules, they were already get the benefit for condoning the educational qualification. That's why, paragraph 18, it is stated that they have to, condone the education qualification in their new rules, but they have not condoned that aspect. In 95 rules, gazette is mandatory. After that, we are our education qualification were condoned, and from gate 3 to gate 2, we are promoted. In the meantime, before the 20 rule scheme. And in the 22 rules, it is, section 25, it is clearly
Where,
stated that-
where do you say that your these conditions were relaxed, educational qualification was relaxed? Where is, when did it happen?
Paragraph 20, in my
Paragraph 20.
or 19, 18, 19, 20. Paragraph 18, can level. Nineteen, madam. So it is not a case that madam, for the first time, this petitioners came before also. Before that, madam, they were promoted, their education purposes were already condoned. From gate 3 to gate 2. Now they are serving students of gate 3. Initially, they were appointed gate 1 or gate 3, madam. They were all madam PU SSLC passed. The government has taken a decision, madam, for condoning the education qualification. And after that, madam, they were promoted from gate 3 to gate 2, madam. Now they are serving the gate 2, madam. And they are again seeking for similar madam, education, condon of the education qualification.
Yes.
No, now, madam, the government
So
has taken
you're
decision,
trying to
madam,
say that
to
you
condone
get,
that.
you got two benefits already.
Madam.
First is at the time of recruitment.
Not
And then-
recruitment, there is no benefit. I have not, we have not given any benefits. Madam. After that, my lord, promotion, my lord, not recruitment. Promotion, gate 3, my lord, we are appointed as a gate 3, my lord, student of gate 3, PU or SLC person. We are promoted from gate 3 to gate 2, my lord, by condoning our education qualification. And now we are
In grade 3, you don't require, what do you call?
gate 3, my lord, either SSLC.
SSLC. Okay.
Admittedly, my lord, we are not, we are candidates, my lord, having not degree qualification. And gate 2 or gate 1, my lord. Essential qualifications, my lord, gauges. And the respondent side, my lord, take a decision, my lord, and they, my lord, considering all the aspects, my lord. Rules 25, my lord, is clearly stated, my lord.
And how do you counter the two decisions cited by Mr. Chaudhary? B.N. Nagarajan and the Syed Khalid Rizvi.
Today, my lord, I am not wicked on that thing.
You are in WPC 5162.
516.
Okay. And what is the third case? 4126, 4216? Mr. Kane Chaudhary, say same. Just a moment. You are at serial number? Okay. Yes, Mr. Fukan.
Lordship, looking for the department, Lordship. Here, Your Lordship, I would like to first refer to the first case, Lordship, which is the E. Raghumani Sinha. Lordship. There, my lord, I would
Yes.
Lordship, would like to directly come to the page 97, Lordship, of my affidavit, Lordship, which I filed in the first case, Lordship.
Page
Page 97.
27.
There, my lord, we have basically, we have a limited say on this case, Lordship.
You are appearing for
I'm appearing for the Secretariat Administration Department.
Secretary Administration Department.
Here, what is happening, Lordship, paragraph 4, page 97. Here we have
Yes.
invoked, Lordship, the principle of section 25, Lordship, the relaxation clause. Since many of the this thing respondents, Lordship, were of different this thing, Lordship, the department took a stand to invoke section 25, Lordship. Wherein, Lordship, the educational qualification of stenographer grade 2 and stenographer grade 3s for promotion to the higher post, Lordship, was relaxed, Lordship. This is the main reason they have done it, Lordship, and that is the stand actually of the department. Whether, my lord, it was correct or not, my lord, I leave it to your Lordship, but since there is a provision, Lordship, which is backed by Article 309 of the Constitution of India, Lordship, and it is in the Assam Stenographer Service Rules 95, section 25. So based on that, Lordship, there are many, actually, Lordship, many stenographers. That's what I could gather. Many stenographers who are not qualified, maybe, because as per the particular rules, but who are actually efficient. In those cases, I think, Lordship, some people had been given relaxation, Lordship. That is the stand. But of course, whether that is applicable, whether they can do that, is the question Lordship has decided. But that is the limited stand which the department has taken. And also, Lordship, regarding direct recruitment, regarding direct recruitment, Lordship, if person is directly recruited, regarding that, Lordship, relaxation cannot be done. But here in this case, Lordship, people have been appointed to promotion from stenographer grade 3 to grade 2. So in that case, Lordship, the department has invoked section 25.
Where is that decision, Mr. Chaudhary was showing us? The cabinet decision, where is that?
It's in the additional affidavit.
My lord,
70
70,
cabinet memorandum.
and accept it.
No, this was not a consideration. Your submission is not a consideration there. That Mr. Fukan,
Hello.
your submission is not a consideration there in cabinet memorandum.
Yeah.
They don't say exceptional qualification.
Yeah.
Subjective assessment has not been made. That they are excellent in their work. That subjective assessment is not there.
My lord. But my lord, could get them. I mean, it's not there, of course, Lordship.
You will kindly see cross 4 of that. It is based on the recommendation of the DPC.
From this side.
Regarding the technicality in learning senior council's matter of challenge to the cabinet memorandum. In our case, my lord, it was filed subsequently, we have challenged it. It's there in our prayer.
This was challenged.
Yes, there is. Yeah, page 18, if your lordship comes to the prayer portion, my lord, we have prayed for a item 3. Prayed for a writ of certiorari for setting aside the cabinet memorandum that the 1850.
That is 4126.
Yes, madam. Item 3.
You filed your affidavit there in that case?
No,
There we haven't filed, it was taken up together, Your Lordship, all these matters. So we had filed in the last occasion, we had filed affidavit in the main case and my lord in the second case, that is 5162. Third case, I think, it's a common affidavit, Your Lordship. Since it's connected.
Which affidavit?
Your Lordship, in the first case, we had filed the on 8/2/23, which is in 365522.
Yes,
Starts at page
95.
94.
Ah.
And that is the affidavit filed in the first case, which is a common affidavit. Since we have used this thing and
It's not a common affidavit.
Lordship, because it was all the matters were tagged together. at
No,
that
that is
time.
okay, but it's not a common affidavit.
And also, my lord, another affidavit was filed. And my lord. May. My lord, May 22,
In 5162.
my lord 5162. That is being filed by my lord, the respondent number 2.
These government affidavits are so difficult to understand. You made a statement in para 10 and it's not supported by affidavit by record, it's by knowledge. What is the new rules?
2020. Amended rules of 2020.
So your officer does not know the meaning of a new rule and a amendment made to the rule. He's a joint secretary. where it can be helped. Okay. Yes, Mr. Anybody appearing for the private respondents? No.
If private respondents in some cases are. He's in the main first case, the second case is 5162, which is Jitu Sekia. The same person has made a private respondent in the
Okay.
first case, so it's between them only.
So you are here and here.
So they're all over it.
Is on all the three worlds.
The private resident of my petition. in front of us.
Even they are there, man.
Okay. For Mr. PN Chaudhary, London Senior Counsel, assisted by Mr. J. Patwari, counsel for the petitioners in WPC 3655 of 2012, Mr. A. Khanikar, learned counsel for the petitioners in WPC 5162 of 2022, and Mr. P. Bharadwaj, learned counsel appearing for respondents for the petitioners in WPC 4216 of 2022. Next para. Also heard Mr. A. Fukan, learned standing counsel for the
2, 3, and 4 in the first case.
standing counsel for the Secretariat Administration Department. It is Secretariat or General Administration?
So it's Lordship, it's Secretariat Administration,
Secretariat Administration Department,
2, 3, and 4.
representing respondent numbers 2, 3, and 4. Okay. Ms. S. Bhagwan, government advocate appearing for respondent number 1. Mr. A. Khanikar, government counsel for the private respondent numbers 6 to 13 in WPC 3655 of 2022.
I appear for respondents 4, 5, and 6. Respondents 4, 5, and 6 in 516.
Also, 4, 5, and 6 you are appearing.
In item in WPC 516.
Okay, I'll make a mistake. You give a slip of paper, you write it down, so I'll incorporate in the order.
Yes.
You also indicate for which respondents you are appearing. Huh? Otherwise, I'll make a mistake. By filing WPC 3655 of 2022, the petitioner therein has assailed the cabinet decision in respect of additional item number 4 in its meeting dated 18/5/2022, by which the educational qualification of the respondent numbers 5 to 13 was of having graduation as a condition for promotion was relaxed, only condoned. And the petitioners have also prayed for recalling or rescinding the said decision to relax the educational qualification of private respondent numbers 5 to 13. With further direction to the respondents to hold the DPC for promotion to stenographer grade 1 within bracket English in respect of remaining 14 vacancies out of the 40% promotional quota. In terms of rule 5 within bracket 3 of the Assam stenographers service rules. 1995 within bracket as amended by the Assam stenographers after stenographers apostrophe stenographers within bracket amended bracket close service rules 2020. Let's start. Next slide. The case of the petitioners in WBC 5162 of 2020. No, not because by filing WBC 5162 of 2020, comma, the petitioners therein have prayed for directing the respondent authorities to condone the educational qualification required for the post of promotion to stenographer grade 1. And for direction to the respondent authorities to consider the case of the petitioners for promotion to the cadre of stenographer grade 1. Next, the petitioners in WBC 4 to 16 of 2022. Have made a prayer similar to the once ONES once made in WPC 5162 of 2020. Next paragraph. The petitioners in WPC 3655 of 2022 and 4216 of 2022 are all graduates in various disciplines, and at different point of time they were appointed as stenographer grade 3 within bracket English in the Assam Secretariat. Stop. In course of time, the petitioners were promoted to the next higher post of stenographer grade 2 within bracket English. Stop. It is not in dispute that the names of the petitioners find place in the provisional gradation list as on 1/3/2019. Full stop. The No, as per the Assam Stenographers Apostrophe Service Rules 1995. Under Rule 5 within packet 5, it is envisaged that the post of stenographer grade 3, the recruitment to the stenographer, to the post of stenographer grade 3 will be made by direct recruitment in accordance with the provisions of Rule 6 and Schedule 1, Roman 1 from Part A. And that the recruitment to the post of stenographer grade 2 is required to be made by recruitment in accordance with Rule 6 and Schedule Roman 1, Part capital B. Full stop. The said Schedule 1, Part B envisages the qualification for recruitment as under page 37. Stenographer grade 2 and grade 1 accurate grade 2 and grade 1. Full stop. Therefore, comma, it appears from the conjoint reading of Rule 5 and Rule 6 of the said 1995 rules, comma, that at the entry level of stenographer grade 3, the recruitment is to be made by direct recruitment. And insofar as recruitment to grade 2 and grade 1 are concerned, it will be made by promotion subject to a candidate having the requisite speed test and would have passed and should have passed the degree examination would have passed no, stenographer grade 2 is direct recruitment.
Initially, it was direct recruitment, but by-way amendment, promotional quota and direct recruitment quota was.
Acha, originally, under the amended rule, stenographer grade two post was to be filled up by direct recruitment by candidates having degree examination. Yeah, no, sorry, degree, who pass the degree, subject to qualifying in this fit test. I have to know. No? First of however, it appears from the amended amendment rules of 2020.
Yes.
2020, that the post of grade two, the stenographer grade two is also made promotional post from those candidates who have rendered 6 years of continuous service as stenographer grade three and have a degree. Full stop. Insofar as promotion to grade stenographer grade one post is concerned, under the under the 1995 rules, the post is required to be filled up by promotion from grade three and grade two both.
Yes.
One from grade three also you can go to grade one.
Okay.
You see this rule page at page 37. A candidate should have completed 6 years of continuous service either in grade stenographer grade two or stenographer grade three, or in both on the 1st of January.
So this, in my humble submission, this is about the qualifying rank.
No, but it says to either grade, either, you see the words are either. If it is either, it will be either grade two or grade three.
Yes, the word is either. What kind of knowledge, either of the.
And where is that amendment notification?
Page 30.
Huh?
Page 30 of the
30,
30.
30. First of, however, in grade three and grade two. Huh? However, it appears that under the amendment rules of 2020, the post of stenographer grade one is required to be filled up from the list of stenographers, from the select list of stenographers of grade two who have completed 6 years of continuous service in the post of stenographer grade two and have passed degree examination from a recognized university. Let's stop. The respondent authorities were contemplating promotion to be made to grade stenographer grade one, and at that stage, the petitioners had moved WPC 5162 of 2020, and this could be order dated 9/12/2020. While issuing notice, I was pleased to direct that the promotion made to stenographer grade one shall be subject to outcome of the writ petition. Next page. Thereafter, on 30/3/2021, the respondent authorities had given promotion to 16 incumbents who were serving as stenographer grade 2, TO2, stenographer grade 1. Full stop. A DPC was scheduled for the purpose of promotion from stenographer grade 2 to stenographer grade 1 on 17/3/2022. Full stop. However, as by that time, WPC 5162 of 2022 was moved, the DPC had deferred their meeting for consideration of promotion to grade 1, stenographer grade 1 service. However, it made a recommendation.
Page 63.
It made a recommendation. No, the selection board advised the advised the department to move for one-time relaxation of educational qualification in respect of the graduate incumbents in both cadres of stenographer grade 2 and grade 3 to make them eligible for promotion to the next higher cadre. Until then, the selection board had decided to defer the recommendation of candidates to fill up the vacancy of stenographer grade 1 and stenographer grade 2 by way of promotion. Pursuant to the minutes of the meeting of selection board held on 17/3/2022, the state cabinet was moved with the views of personnel department and the finance within bracket ESST full stop dash capital A department. Proposing grant of approval for one-time relaxation of educational qualification in respect of the state stenographers grade Roman 3 and grade 2 for the post of stenographers grade 2 and grade 1 of Assam Secretariat. Full stop. Thereafter, the state cabinet, which is that page
Page 70 of the edition.
70.
70. Running page 70.
No, this is the 70/71 is the
Cabinet,
no, where is the decision?
cabinet, order is on page 77.
Yeah, the cabinet took a decision to relax the educational qualification of 11 numbers of stenographers within bracket grade 2 for promotion to stenographer grade 1 by relaxing the rules by invoking Rule 25 of the Assam Stenographers apostrophe Service Rules 1995. Next paragraph. The learned senior counsel for the petitioners has submitted that initially when stenographers of grade 3 were promoted to grade 2 by relaxation of the rules, that was a wrong action taken on part of the respondent authorities, because and in this regard it is submitted that the educational qualifications required for promotion could not have been relaxed, and therefore one wrong cannot be perpetuated to commit another wrong. Full stop. It is further submitted that the DPC was required to give their recommendations, and instead of recommending promotions, they gave advice to the department to move the cabinet for relaxing the rules. Most of the DPC was headed by the then Chief Secretary of the state, and the respondent authorities carried out the advice of the DPC headed by the Chief Secretary by moving the cabinet, and the cabinet took a decision in favor of relaxing rules under by invoking Rule 25 of the 1995 rules to give promotion to 11 candidates who were arrayed as private respondents in the in WPC 3655 of 2022 and WPC 4216 of 2022. Stop. In order to support the contention that conditions of recruitment cannot be relaxed, reliance is placed on the case of Syed SYED, Khalid KHLID, Rizvi RIZVI, etc. versus Union of India and others within bracket 1993, bracket post supplementary within bracket 3, SCC 575. And in order to support the contention that power to relax cannot be exercised to override the relaxation of rules is not permissible in exercise of executive power of the government under Article 162 of the Constitution of India to override the recruitment rules framed under Article 309 of the Constitution of India. Reliance is placed on the case of B.N. Nagarajan versus State of Karnataka within bracket 1979, bracket close 4 SCC 507. Next paragraph. Supporting the opposition to prayers made in WPC 3655 of 2022 and WPC 5162 of 2020, 4216 of 2022, the learned counsel for the private respondents and the petitioner in the WPC 5162 of 2020 has submitted that the government had the power under Rule 25 of the 1995 rules to condone the requirement of having graduate as a educational qualification for promotion to promotion from stenographer grade 2 to stenographer grade 1. And it is submitted that as the power was relaxed by while the petitioners in WPC 5162 of 2020 were promoted from stenographer grade 3 to stenographer grade 2, the exercise of such power was permissible and justified by the learned counsel for the petitioner in WPC 5162 of 2020. Next paragraph. A similar situation, a similar submission is made by the learned standing counsel for the Secretariat Administration Department, to the effect that the government had the power to relax rules by invoking section 25 or rule 25 of the 1995 rules for promoting the stenographer grade 3 to stenographer grade 2. Yeah, Ms. Barwa, you are also supporting the same stand? You are also supporting him, the learned government advocate also supports the contention of the learned standing counsel for the Secretary of Administration Department. Next, it would be appropriate to refer to Rule 25 of the Assam Stenographers Service Rules 1995, which provides for power to relax. Which page 35, and the equipment rules. From the text of Rule 25 of the 1995 rules, the first requirement is that the government must be satisfied that operation of any of the rules is causing any hardship in a particular case. In the present case in hand, no material has been brought on record. To show that how the operation of the rules relating to prescription of educational qualification of being a graduate to be eligible for promotion from stenographer grade 3 to stenographer grade 2, and from stenographer grade 2 to stenographer grade 1 was causing any hardship in any particular case. Post. It appears that the only justification for moving the cabinet memorandum was that the DPC held on 17/3/2022 under the chairmanship of Chief Secretary Assam advised the General Administration Department to move for one-time relaxation of educational qualification in respect of the undergraduate stenographers, grade 3 and grade 2, to make them eligible for promotion to the next higher cadre. And accordingly, a proposal was made before the cabinet for relaxation of the required educational qualification. Full stop. Next, the personnel who have joined service with a particular educational qualification are deemed to be aware of the requirement of having a higher educational qualification to become eligible for promotion to stenographer grade 2 and stenographer grade 1. The candidates who were not graduate had entered service as stenographer grade 3 with open eyes, knowing that the requirement to be promoted to stenographer grade 2 and grade 1 was that they have to be a graduate. There is nothing on record to show that the candidates who were not graduates had applied for acquiring the graduate degree but they were not permitted to do so by the appropriate government. To stop. Therefore, lethargy on part of the candidates who were not graduates to obtain such a degree cannot be said to be cause for hardship to any such stenographer of grade 3 who did not have the requisite educational qualification to be considered for promotion to from stenographer grade 3 to stenographer grade 2, or for being promoted from stenographer grade 2 to stenographer grade 1. To stop. Next para. The relevant paragraph (33) of the case of Saeed Khalid Rizvi within bracket Supra is extracted below. So from above, it is crystal clear that in the said case of Syed Khalid Rizvi within bracket Supra, it has been held that appointment to a post in accordance with the rules is a precondition, and that the conditions of recruitment, rules of recruitment cannot be relaxed. Next para. Rule 25 of the 1995 rules is somewhat like a residuary rule, which empowers the government to relax the rules. Yet, comma, from the provisions of Rule 25 quoted above, it does not appear that the government is empowered to relax the conditions of recruitment. The Supreme Court of India has also reiterated the view that there cannot be that there can be no relaxation of the basic fundamental rules of recruitment in the case of Suraj SURAJ Prakash PARKASH Gupta versus State of Jammu and Kashmir. Citation to supplement. Similarly, in the case of Keshav Chandra Joshi versus Union of India, what is that citation?
My lord, Keshav Joshi is my lord 1992 supplement 272,
1992,
supplementary 1 SCC.
supplementary 1 SCC,
Page
272.
Yes, and para 33 is very relevant because, my lord, in that case also, there was a rule 27, like us, where in case of undue hardship, government could relax.
Yes, Master. Wherein, citation given. Wherein also it has been held that
Perimeter conditions were there.
that the perimeter rule 26 therein, 26. Here it is 26.
27.
Perimeter rule 27, which was
Para 33.
which was being considered in this said case, did not permit relaxation of conditions of service. And it was held by the 3 judge bench that the rule did not permit relaxation of recruitment rules.
Para 33.
So para 33 of the said decision is quoted below. Next para. The case of B.N. Nagarajan Vidyamelekar Supra, cited by the learned senior counsel for the petitioner. He is an authority on the point that when the rules framed under Article 309 of the Constitution of India are in force, no regularization is permissible in exercise of the executive powers of the government under Article 162 of the Constitution of India in contravention of the rules. Para 25 thereof is extracted below. Next one. In view of the discussions above, the court is inclined to hold that the cabinet decision taken pursuant to cabinet memorandum circulated wide memo number capital SAE full stop 124 of 2016 by the Principal Secretary to the Government of Assam, General Administration Department on the subject of relaxation of rules, educational qualification in respect of stenographers grade 3 and grade 2 who are otherwise eligible for promotion to the post of stenographers grade 2 and grade 1 of Assam Secretariat dash one-time relaxation. Which has been circulated wide. No, which has been notified wide notification number capital GA within bracket capital SAE bracket closed full stop 124 of the 2016 of the 180 dated 1/6/2022 to page 77. My allowed to stand would be in contravention to the rules of recruitment provided under the Assam Stenographers apostrophe Service Rules, 1995, as amended White. Assam Stenographers
Page 3
30. Assam Stenographers Service, within packet amendment, packet close rules 2020. And therefore, they said cabinet decision, which is transformed into a notification dated 1/6/2022, referred above, is not found sustainable, and the same is likely to be set aside and quashed. By holding that the conditions of recruitment cannot be relaxed and that the government does not have the executive power under Article 162 of the Constitution of India for relaxing the conditions of recruitment as provided under the Assam Stenographers Service Rules, 1995, which is which has been brought into force by exercise of power under Article 309 of the Constitution of India. Next, accordingly, WPC 3655 of 2022, as well as WPC 4216 of 2022 stands allowed. Next, the the contention of the petitioners in WBC 5162 of 2022 stands repelled. They are the private respondents in the two other 8 petitions. And the said contention in in defense of the private respondents are also repelled. And accordingly, it is held that the petitioners in WBC 5162 of 2020 have not been able to make out a case for issuance of direction to the respondent authorities to relax the educational qualification required for the post of stenographer grade 1 by promotion from the cadre of stenographer grade 2. And accordingly, they are free to direct the respondent authorities to consider their cases for promotion to stenographer grade 1. Is also not sustainable and is said, and the prayers made in said petition stands refused. Next para. Resultantly, the competent authorities of the state government would be at liberty to constitute the DPC for promotion to the post of promotion from stenographer grade 3 to stenographer grade 2, sorry, grade 1, in accordance with the existing recruitment rules. Next para. This court by interim order dated 9/12/2020 passed in WBC 5162 of 2020 had provided that promotions made to the post of stenographer grade 1 under the Secretariat Administration Department would be subject to outcome of the writ petition. So accordingly, as this court has held that the promotion of persons who are not graduates in the cadre of stenographer grade 2 could not have been promoted to stenographer grade 1 consequently the promotion made to the incumbents whose name appear in the notification under memo number SAE /11/2011 /61 dated 30/3/2021 is liable to be set aside and quashed. Being subject to the outcome of WBC 5162 of 2020. Next para. WBC 5162 of 3655 of 2022 and WBC 4216 of 2022 stands allowed as indicated to the extent as indicated above. WBC 5162 of 2022 stands dismissed. Next, the parties are left to bear their own cost.
Keep them like that.
It will vary. I will be all closed in your orders passed.
On idea, we have selected, 160% order.
I give you order passed. ISS. Continue to.
Keep them.
Madam, item 5, madam, can it be after a week, madam? Instructions are awaited, madam. There is a matter, madam, pending at 2, madam. Item 4. Next item, madam.
Item 4. Just a moment, I forgot. 21
Madam, after a week, madam.
after the.
Yes, I will have the instruction.
What says that you represented?
4. Item 4.
On the care maintenance, Vivi Bovek, Bernard, standing for
Health
the
department.
health department. Just after a week to enable him to obtain instructions.
Right.
Interim order is there? No,
Lordship, may kindly fix a date, Lordship.
Huh?
Lordship, may kindly fix a date.
Give a date after a week. Give a date in this case after a week.
9/8.
Yes,
Sorry, sir.
I'll have
it's okay.
There is a matter before division bench at 2 o'clock. I have a matter item number 8, minor. In the morning, I made a prayer to be brought on record, but your lordship is right, as an IA. Affidavit can be brought, not the IA. Your lordship is right, so let this IA be, it has
No,
been
it could have
numbered.
been brought today also, but it can't be brought on record like this.
Yes, yes.
I asked him that can give it to
Your
the
lordship is
person,
right.
it will be listed and brought in.
Yeah,
It could have been brought.
correct, library, it has been listed. I will not trouble today, my lord. That is not, there are other matters also. So which are, can it be on Monday or Tuesday?
Whatever
Whichever
date you
is
want.
convenient.
Whenever you want. Whenever you want, you suggest a date.
Tuesday to Monday. Tuesday, my lord.
Election petition.
Or Tuesday, there is a election matter. Coming up.
Wednesday, man.
Wednesday, Monday or Wednesday, whatever you want.
Wednesday, man. 8. Wednesday, I have on 5.
Both sides are duly represented. Mr. D. Das, Learned Senior Counsel for the.
I has been numbered as 215.
Traditional,
56. 2156.
assisted by
RP
Mr. R.B.
Kukan.
Fukan. Learned Counsel submits that an interlocutory application has been filed in the matter,
Yes.
which is listed, which is registered as IA Civil
2156 of 2023.
2156
56.
of 2023. Which is not on record. So accordingly, as per, list the matter on 3, on 2/8.
It's a something.
2 is tomorrow.
Wednesday. Wednesday.
2 is tomorrow.
Tomorrow is 2.
Yeah.
Yes. Yes,
So, along with this
tomorrow.
interlocutory application.
Yes, repeat.
Yes.
One of the petitioners before your lordship were appointed from the period 2006 to 11 as my lord daily wage earner in the my lord Assam Medical College and Hospital, Dibrugarh. Initially, what happened, my lord, there are 46 posts were censored for such only category of posts, and out of which, my lord, now some wage earners were regularized. Now, at present, my lord, there are 26 daily wage earners, out of which, my lord, 11 are getting regular scale of pay. And my lord, the petitioners have been deprived. Lordship, will I kindly come to page 45 of the petition, my lord. Annex 11, page 45.
But this
Is that-
daily wage earners,
My lord.
I think their services have been outsourced.
Not
Yes,
outsourced, my lord. They have been directly recruited by the superintendent of the hospital. And it's a squarely covered case by an honorable dividend bench judgment of this honorable court. The facts of this case, the relief what I am praying for is squarely covered by a judgment of the honorable dividend bench passed by this honorable court. Madam, page 45, madam. This is a letter written from the Superintendent Assam Medical College to the Director of Medical Education Assam.
Yeah, you are referring to the case of Upen Das.
Yeah.
Just a moment. Yes, you have not filed an affidavit.
No, Lordship. Actually, my senior on legs in code number 5, Lordship.
Mr.
Who?
DP Bora appears as a standing counsel Health Department.
Okay,
In the morning, we had a discussion. He said he doesn't have any objection regarding allowing the petition in terms of Upen.
but let him be here.
Let him be.
No, if that is the Upen Das is the only question, then we will not go into the merit of the matter.
After some time, man. Deeply.
6 and 7.
Yes,
May it please, Your Lordship. Your Lordship, cite the brief facts of the case, Your Lordship, because I won't trouble Your Lordship with the previous facts which led to his suspension. But I'll straightly come to the point here. Your Lordship, the petitioner, he is presently working as a superintendent engineer in the Borderers organization. And the year 2015-16, he went on deputation to NHIDC as a executive director. Now, when he was deputed there, a particular work order, a tender was awarded in favor of one contractor. And he was member of the technical evaluation committee. And he was a chairman, and there were other members also. Now, after the work order was awarded in favor of that particular contractor, the department NHIDCL, they inquired regarding the veracity of the certificates deposited by that particular contractor. And after verification, the department came to know that the certificates that were actually deposited by the contractor was forged. And then they started an internal inquiry. And that particular contractor was debarred and his contract was cancelled. Now, the contractor, he then approached the Delhi High Court Mediation Center, challenging that particular termination order. And he produced one particular audio clip saying that the petitioner asked for illegal gratification. Without having any other proof, just the audio clip and the veracity as such, whether that particular voice recording was his or not, he alleged that they alleged that he had sought illegal gratification. And based on that allegation, they suspended him. The suspension order is at page number 104. It's dated 1st November 2022. Your Lordship, if I may read out, because it has got certain ramifications.
page.
Page 104, Annexure 12. Whereas a disciplinary proceeding against Sri Vinay Kumar Singh, SC Civil of R&D establishment, arising out of a case of allegedly obtaining illegal gratification while he was on deputation with NHIDCL is contemplated or pending.
Now therefore, in exercise of powers conferred under sub-rule 1 of Rule 10 of the CCA Rules 1965, the officer Sri Vinay Kumar Singh is hereby placed under suspension with immediate effect. Now this particular order was transmitted, next page, on 4th of November 2022 and received by the petitioner on 7th of November 2022. This particular date has got a special significance, Your Lordship, because after this particular order, suspension order was issued to the petitioner, the respondents, they were supposed to conduct a review as per Rule 10, Sub-Rule 6 and Sub-Rule 7 of the CCA rules within 90 days of the date of suspension, from the date of suspension. Now, in my humble understanding, Your Lordship, this date of 90 days would start from 1st of November 2022, when this particular suspension order was issued. And this particular 90 days period would end on 29th of January 2023, in my respectful submission. But the respondents, instead of reviewing this within this 90 days period, they reviewed it, they issued the review order on 3rd of February 2023. Now,
You say it was, 90 days would expire on 28th January,
29th of January,
29th of January.
29th of January. After 29th of January, the suspension order automatically gets revoked because of the applicability of Rule 10, Sub-Rule 6 and Sub-Rule 7. Now,
The review was done when?
on 3rd of February 2023. Now, in this regard, Your Lordship, I have quoted Sub-Rule 6 and Sub-Rule 7 at page number 20 of the writ petition. If I may just read out. Para number 17, Sub-Rule 6. An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority competent to modify or revoke the suspension before expiry of 90 days from the effective date of suspension, on recommendation of the review committee constituted for the purpose, and pass orders either extending or revoking the suspension. Subsequent review shall be made before expiry of the extended period of suspension. The extension of suspension shall not be for a period exceeding 180 days at a time. Now, Sub-Rule 7 is important here. An order of suspension made or deemed to have been made under Sub-Rule 1 or Sub-Rule 2 of this rule shall not be valid for after a period of 90 days unless it is extended after review for a further period before the expiry of 90 days. Now, in this regard, Your Lordship, the law is settled with regards to the landmark judgment of Deepak Mali. If I may place this particular judgment for Your Lordship's consideration. The citation is 2010 2 SCC 222. The relevant paragraph is paragraph number 10 and 11.
Yes.
Now, paragraph 10 says, having carefully considered the submissions made on behalf of the parties and having also considered the relevant dates relating to suspension of the respondent, and when the petitioner's case came up for review on 28th of October 2004, we are inclined to agree with the views expressed by the Central Administrative Tribunal as confirmed by the High Court that having regard to the amended provisions of Sub-Rule 6 and 7 of Rule 10, the review for modification or revocation of the order of suspension was required to be done before the expiry of 90 days from the date of order or suspension, and as categorically provided under Sub-Rule 7, the order of suspension made or deemed would not be valid after a period of 90 days unless it was extended after review for a further period of 90 days. Now, paragraph number 11, the case sought to be made out on behalf of the petitioner, Union of India, as to the cause of delay in reviewing the respondent's case is not very convincing. Section 19, Sub-Rule 4 of the Administrative Tribunal Act 1985 speaks of abatement of proceedings once an original application of the said act was submitted. In this case, what is important is that by operation of sub-rule 6 of Rule 10 of the 1965 rules, the order of suspension would not survive after a period of 90 days unless it was extended after review. Since admittedly the review had not been conducted within 90 days from the date of suspension, it became invalid after 90 days. Since neither there was any review nor extension within the period of said 90 days, the subsequent review and extension, in our view, would not revive the order which had already become invalid after the expiry of 90 days from the date of suspension. So, Your Lordship, this particular judgment has been followed in a number of judgments laid down by this honorable division bench of this court as well as coordinate bench of this court. Now, the only question which would actually basically remain is to the effective date of suspension. Because the stand taken by the respondents herein is that the date of suspension would run from 7th of November 2022, when I had received that particular suspension order.
That is
And-
right, I think.
And my stand is basically, it would actually run from the date of issuance of the order. In
No, I
that,
think the former would be correct. The letter would come only if there is no date of, what you call,
no,
receipt.
no, Your Lordship, that is where, Your Lordship, there is a settled law with regards to this. I had actually placed one judgment of the Supreme Court, titled State of Punjab versus Khemira. I placed it on last occasion when it came up before Your Lordship. The
Yes.
relevant paragraph is paragraph number 17, last page. And herein, the Honorable Supreme Court said that no, it would run from the date of issuance and not from the date of receipt. I had pointed out the 14th line, Your Lordship, for Your Lordship's convenience. I'd like to read it out from that line. It will be seen.
Yes.
It will be seen that in all the decisions cited before us, it was the communication of the impugned order which was held to be essential and not its actual receipt by the officer concerned. And such communication was held to be necessary because till the order is issued and actually sent out to the person concerned, the authority making such order would be in a position to change his mind and modify it if it thought fit. But once such order is sent out, it goes out of the control of such an authority, and therefore there would be no chance whatsoever of his changing his mind or modifying it. In our view, once an order is issued and it is sent out to the concerned government servant, it must be held to have been communicated to him, no matter when he actually received it. We find it difficult to persuade ourselves to accept the view that it is only from the date of the actual receipt by him that the order becomes effective. If that be the true meaning of the communication, it would be possible for a government servant to effectively thwart an order by avoiding receipt of it by one method or other till after the date of his retirement, even though such an order is passed and dispatched to him before such date. An officer against whom whom action is sought to be taken thus may go away from the address given by him for service of such orders, or may deliberately give a wrong address and thus prevent or delay his receipt and be able to defeat his service on him. Such a meaning of the word communication ought not be given unless the provision in question expressly so provides. Actual knowledge by him of an order where it was one of dismissal may perhaps become necessary because of the consequences which the decision in the state of Punjab versus Amar Singh contemplates. But such consequences would not occur in the case of an officer who has proceeded on leave and against whom an order of suspension is passed, because in his case, there is no question of his doing any act or passing any order, and such act or order being challenged as invalid. Now, the law as such, this particular judgment is a 4-bench judgment of the Honorable Supreme Court, and it is still good law till date, Your Lordship. The citation is AR 1970 SC 214. So, my humble submission, Your Lordship, this date of suspension would run from, since it is of immediate effect.
No, you see, and the facts of this case, what had happened was this Khemi Ram case.
Yes, sir.
Here, the order of suspension was passed and he avoided service, and in the meanwhile, on a particular day, he retired.
Yes.
Thereafter, he took a plea that I have received this after my retirement,
Yes,
and therefore it could not have been done.
Yes,
So therefore, that was being interpreted.
yes.
So if an unscrupulous person does not accept it within the due date, but it is not so in your case.
I was on leave at that point of time. That's why I received it late, Your Lordship. And I had received by email also on first.
So therefore, it's a date on which you are actually served. It can't be interpreted to mean the original date when it was issued.
But my understanding from the judgment which follows fell from the Honorable Supreme Court is basically from date of issuance.
Date of communication.
So that
It is there.
particular, that is where this whole issue is stuck, Your Lordship. Because in my respectful submission, this is from a date of issuance of that particular, and the Honorable Supreme Court specifically says that it is from a date of issuance of the suspension order and not from the date of receipt.
No, because that interpretation would have made this made the claim in this repetition infructuous. Here, what happened, he had avoided that. Supreme Court came to a finding that he avoided, and therefore it was interpreting that actually it would be a date of issuance in this case. And this is not a general law that
It has been followed. I can produce other judgments also on the same context. But I have actually gone to the root of the whole, the original judgment, this Kemiram judgment, and it has been followed
Yeah,
in a
only
plethora of cases, Your Lordship.
31st July communicate the date of effect of the suspension or 2nd August. They receive after retirement 4th of August. So we receive 4th of after retirement. So their case is there. Now, this fact is completely different here.
Also, Your Lordship, this whole issue of suspension, if I have to rely upon the Ajay Chaudhary judgment also, now that the whole disciplinary proceedings have started and charge memo has been issued way back on 10th of April 2023, he is not in a position to tamper with any evidence or as such influence any witness. And more particularly, when the whole incident, alleged incident occurred in NH, when he was there in NHIDCL. Now, the whole disciplinary proceedings are going on in VRO. He has been repatriated back to the parent department. And what has happened, he has been confined to the quarters and he has not been granted leave also for the past 9 months since November 1st, 2022. He is here in Guwahati and he is not being allowed to go on leave also, even though right now the disciplinary proceedings have started. And right now, inquiry officer was just appointed, but since the whole department has such bias, because I had challenged it earlier when this charge memo was issued, but then again, I relied on one Supreme Court judgment when basically other members of the technical evaluation committee were not made any kind of, they were not issued any charge memo or suspended for that matter. And only he was being singled out and he was being suspended and charge memo was issued. That was held to be against bias and totally malified with a malified intent. I'll challenge it later on when this whole disciplinary proceedings culminates, because that will have to attain a final. But now, keeping him under suspension based on Ajay Chaudhary's judgment and facing all kind of insinuation and humiliation.
what is the date of issuance of notice here? 1st of November.
1st of November.
Last line also, your lordship may pay us last paragraph 3,
Just a moment, I'm just.
104.
Okay. So
And
that is-
also, if I may rely upon the Ajay Chaudhary judgment, Your Lordship, certain paragraphs with regards to prolonged suspension and the need for, because that and the need for actually keeping under protracted suspension, that is not actually called for in my humble submission. Mainly paragraph number 7, 8, and 9. When the Honorable Supreme Court specifically dealt with this particular issue as to why a particular government servant should not be just simply kept under suspension and treated as a punishment. Because that is what they are doing right now. Because just the day before yesterday, they have again extended my suspension period and handed me over this extension of the suspension period for till January 2024. During the pendency of this writ petition.
Yes. In Ajay Chaudhary, which paragraphs you are relying on?
I am relying upon paragraph number 9, Your Lordship, of the Ajay Chaudhary judgment. Protracted periods of suspension, repeated renewal thereof have regrettably become the norm and not the exception that ought to be. The suspended person suffering the ignominy of insinuations, the scorn of society, and the derision of this department not to endure this excruciation, even before he is formally charged with some misdemeanor, indiscretion, or offense. His torment is his knowledge that if and when charged, it will inexorably take an inordinate time for the inquisition or inquiry to come to his culmination. That is to determine his innocence or iniquity. Much too often, this has now become an accompaniment to retirement. Indubitably, the sophist will namely counter that the Constitution does not explicitly guarantee either the right to a speedy trial, even to the incarcerated, or assume the presumption of innocence to the accused. But we must remember that both these factors are legal ground norms are inextricable tenets of common law jurisprudence, antedating even the Magna Carta of 1215, which assures that we will sell it to no man, we will deny to no or defer to any man, either justice or right. In similar vein, the Sixth Amendment to the Constitution of the United States of America guarantees that all criminal prosecutions accused shall enjoy the right to a speedy and public trial. Now, so basically the whole gamut of this particular paragraph is that prolonged, protracted suspension without any due cause, and even this particular review has to be based on some explicable reasons. They have not stated any reasons as to why this protracted suspension has to go on and on and on forever and treat it as a punishment. Because if your lordship peruses to the impugned review order also at page number 106, they have not mentioned as to why my protracted suspension is necessary in the interest. What is that particular reason? Whether I will temper, or in the affidavit also they have not stated as such where that I have protractedly tampered with the evidence or basically influence any witness, nothing of that nature. Simply for the sake, it's a mechanical order saying that your suspension is hereby extended, nothing else.
Something here.
Because even Ajay Chaudhary at para number 14 says that after the charge memo is issued, the reason order should be passed for extending that particular suspension order. That is missing in this particular.
No, here you see this, why I'm trying to read this Ajay Chaudhary.
Yes.
If you please come to para 11.
Yes, Lord.
First come to para 2. Page 2.
Yes.
In the middle somewhere you will find prepared by the subordinate servants of staff in this background that he received the suspension order dated 30/9/2011. In the middle,
Yes, Your Lordship.
correct?
It was in this background that he received.
Yes. So now. Next, after 3 lines, on 28/12/2011, the appellant suspension was extended for the first time.
For a further period of 180 days.
Correct.
Yes.
Now, again, another dates are given,
Yes.
effective from 26/6/2012.
For another 180 days.
Thereafter, suspension was ordered on 21/12 to 2012. It came to be extended for the fourth suspension, yet another period of suspension from 22/11/2013.
Yes, 90 days.
Now you come to this para 11. Last about 4 lines from below, 5 lines. Keeping those factors in the cat in beyond case directed that the suspension will not be extended beyond 90 days from 19/3/2013. 19/3 is a date which is not there in para 2.
The Lordship is reading from which para?
Para 11,
Para 11.
last 4, 5 lines.
Yes, yes, Your Lordship.
19/3.
Yes,
Therefore, there is a date which is not there in para 2.
19/3.
Yes.
Yes, Your Lordship.
This 19/3 is a date which is not there, period. Anywhere.
It is from 22/3/2013.
22/3.
Yes, Your Lordship.
But here you are getting the date of 19/11 in para 11.
Yes, Your Lordship. Maybe some because of some typographical mistake.
No, may not be. So therefore, the interpretation of 90 days from the date of issuance of the notice is not a factor which is
Lordship may also come to para number 14. Last stage of the judgment. We therefore direct, Lordship, that particular paragraph.
yes.
We therefore direct that the currency of a suspension order should not extend beyond 3 months if within this period the memorandum of charges or charge sheet is not served on a delinquent officer or employee. If the memorandum of charges or charge sheet is served, a reasoned order must be passed for the extension of the suspension. As in the case in hand, the government is free to transfer the concerned person to any department in any of its officers within or outside the state so as to sever any local or personal contact that he may have and which he may misuse for obstructing the investigation against him. The government may also prohibit him from contacting any person or handling records and documents till the stage of his having to prepare his defense. We think this will adequately safeguard and universally recognized principle of human dignity and the right to a speedy trial, and shall also preserve the interest of the government in the prosecution. We recognize the previous constitutional benches have been reluctant to quash proceedings on the ground of delay and to set time limits for their duration. However, the imposition of a limit on the period of suspension has not been discussed in prior case law and would not be contrary to the interests of justice. Furthermore, the direction of the CBC that pending a criminal investigation department proceedings are have to be held in abeyance stands superseded in view of the standard adopted by us. Now, that is not applicable to my case because no criminal prosecution or criminal charges has been alleged against me. Only that this particular suspension order and resulting disciplinary proceedings. Now, disciplinary proceedings have started, charge memo has been issued. And now I believe there is no need to keep me incarcerated in the suspension and put under suspension without any justifiable reason as such, because the impugned order also doesn't say anything with regards to the need for keeping me under suspension for a period of 180 days. Even the new order itself doesn't reflect any reason as such. So I heavily rely on this paragraph number 14 of the Ajay Chaudhary judgment with regards to the reasons being adduced in that review order, which is missing in my humble submission. Also, I would like to place one division bench judgment of this honorable court of the Nagaland bench. Citation, it's not there. It's writ appeal number 5 of 2019 of the Kohima bench. And more particularly paragraph number 15. If I may just read out.
Just a moment. What does the CCS rule say
With regards to suspension, Your Lordship.
about this suspension and issuance of notice? What does it say?
Suspension
And issuance of notice. What does it say? CCS,
under rule 10(1).
CCS 10(1). This will be CCS, CCA rules.
CCA rules 1964. Nineteen 65, I'm sorry. Rule 10(1). And rule 10(4)(b).
10(4)(b).
B, where a government servant is suspended or is deemed to have been suspended, whether in connection with any disciplinary proceeding or otherwise, and any other disciplinary proceeding is commenced against him during the continuance of the suspension, the authority competent to place him under suspension may, for reasons to be recorded by him in writing, direct that the government servant shall continue to be under suspension until the termination of all or any of the such proceedings. And then C, an order of suspension made or deemed to have been made under this rule may at any time be modified or revoked by the authority which made or is deemed to have been made the order or by any authority to which the authority is subordinate. And then comes rule 10(6) and 10(7).
Yes, Mr. Mehdi. When according to you is the service, Supreme Court says it will be the date of issuance of notice.
My lord.
What according to you will be the date of service? Because Supreme Court says that it is from the date of issuance.
The date of issuance of the order. But here, my lord, this judgment shows by in my Punjab case, my lord, the date of communication, my lord. My lord,
No, this says date of issuance. This says date of issuance.
These other cases, my lord, it was filed by the respondent that they have received, my lord, subsequently, my lord. That was the case, my lord. Here, in cases, my lord, they issued this, and it is also the order, these 104, my lord. Last paragraph, my lord, I'm reading. It did further order that during the period of this order shall remain in force. The headquarters of Binay Kumar Singh, so and so, should be in the headquarters of Guwahati. Said order shall not leave so and so. Well, from when this order enforcement, he will be dear, and he was handed over the suspension order on 7, Yeah, before that, he was on leave, his leave was granted, he was in Sri Lanka, he was handed over this order, and from that, he will this order enforced, and accordingly, he was in Guwahati, So, we have, as per query of this honorable court file, we have filed an additional affidavit, Affidavit is page 114, 114 and 115 is the relevant person. And my lord, is this whether the salary also suspension allowance salary is also from the 7th of November, my lord. That was, my lord, never question, my lord, is this I've suspended from the 1st of November. Why you are giving the suspension allowances from 7th of November? He's received the suspension allowance from 7th of November. And my lord, now it is continuing, my lord. And in said affidavit, we filed affidavit in 115.
But Mr. Medhi, for last about 6.5 years, you may not believe it, but I have never seen my pay slip. You may not believe it, but I have not seen my pay slip.
Yes, but here, my lord, this man, my lord, this involvement, my lord, that man, my lord. My lord, 199 crores, my lord, 89 lakhs, my lord, this is a person involved, my lord.
I received the form at the time of my, for the purpose of my income tax, filing my income tax. What is that form? 16?
Form 16. Form 16.
Form 16.
Form 16.
I get it and I give it to my
Yes, I know.
chartered accountant. But I still don't see it. I never cross-check.
My lord, some people
So
are
today
like this, my lord.
if you ask me today what pay package you take home, I don't know. Apart from, I can only tell from my bank account that this much has come.
We are also, my lord, from the accountant general council, my lord, he is my lord. We are never asking how what amount is deposited, my lord. And but these people are, my lord, this involvement in the Bhutan project, my lord. He was a director, my lord. And the person against whom this it was offered, my lord, and there is no existence as per Bhutan government also, my lord. My lord, he is 199 crores, 89 lakhs, 12,000, my lord, is involved. This project was, my lord. So, my lord, this and my lord, this whatever, my lord, this man, my lord, this he filed during the pendency of the writ petition also, my lord. When the departmental proceedings started, he filed objection against the inquiry officer, my lord, and for delaying the matter, my lord, and the ministry, my lord. Ministry recently rejected his prayer, my lord. So these only to how to rescue, my lord, this is the main aim of this writ petition, my lord, from this, my lord. So, my lord, this is and so far this the effect of the suspension order, my lord. It was, my lord, I have read, my lord, this it will be enforced, my lord, from particular date, my lord, where he will be in custody in Guwahati headquarters, my lord. Whatever. So, my lord, 7th of this November, my lord, he was handed over, my lord, and before he was on leave, my lord, and accordingly, this on the date of communication is 7th, my lord. So, in this regard, we have filed an affidavit before this honorable court, as per the honorable court already asked what's the effect of the suspension, my lord, order will be. Let's see in paragraph 4, my lord. Although suspension word of the petition was issued, bearing number so and so on 1/11/2020, but same was handed over to the 7/11. As a suspension will come into effect from 7/11/2020, not from 1/11. Further, it is stated that deponent that the first review of the suspension order 3rd February 2023. So only, my lord, here, my lord, his calculation 29 January. My lord, this it was, my lord, this 3rd of February, my lord. The other cases, my lord, this on various occasions it was extended, my lord. This is the first time, my lord, this as per he was handed over the suspension order of 7. And accordingly, he received the email. The other the Punjab case, my lord, is their allegation, my lord, we have received after retirement. This is not a case of retirement. He is in service, my lord. And only this their case, my lord, is after retirement, you cannot issue a suspension order. So this Punjab case, my lord, is first my learned friend read, my lord. This date of communication, my lord, it was communicated on the 31st July and with effect from 2nd of August, my lord. So, my lord, the Honorable Supreme Court says that it will be from date of communication. So here, my lord, from part date of communication is, my lord, from our part, my lord, it was 7th of November, my lord. So in this case, my lord, within the time it was
No, that is not the correct interpretation of that judgment. This Khemiram is not from the date of communication. It says that deemed communication would be from the date of issuance.
My lord, this I read, my lord, this. Last, my lord, 18, my lord, in view of, we must hold that the order of suspension was validly passed and was communicated to the respondent before 4th of August. 4th August was my date of retirement. Therefore, it was effective from July 31st. 31st July, he was communicated, my lord. Accordingly, we are allowed a state appeal and set aside a judgment on order of the High Court. But the High Court did not decide the aforesaid three question raised on we remand the case. My lord, this was, my lord, from date of communication. It was, my lord, when he was in other state, my lord, he was given leave, my lord, in the Punjab case, my lord. Okay. So, my lord, he was in a native place. He was through, my lord, telegram, he was coming on 31st July. With effect, the suspension was effect from 2nd of August, my lord. But he received, my lord, after 4th of August, after retirement. This case, my lord, this we receive after the 4th of August after retirement. So after retirement, they cannot issue suspension order. So here, the date of communication is 31st July. Here also, our date of communication is.
You have this judgment.
Yes, my lord.
Come to para 4. On 31st July, the Punjab government sent a telegram. Received P1 to the respondent at his home address as the respondent already left for his home. Town on leave granted to him as opposite. The telegram informed him. Therefore, you see the communication here is by way of a telegram. And therefore, the Supreme Court says that the
Effect from 2nd of August.
the effect is from 31st of July.
My lord, the telegram informed that he had been suspended the service with effect from 2nd of July to 1958. But this is his, my lord, effect from this effect,
So
my lord,
therefore,
but he was
even
communicated 31st July.
Therefore, even the telegram, the date of communication.
Yes, my lord. Here also our we communicate to him, my lord. This, my lord, the lordship may also, my lord, there is another, my lord, this 105, my lord. 105, my lord, your lordship may turn my next 13. Forwarding of suspension order. Of the
Page
105, my lord, in extra 13.
Yes.
Ink signed copy so and so order bearing so and so is says explanatory is enclosed herewith. The attached acknowledgement in token of having received of the order be returned to so and so duplicate duly and endorsing your signature with date for further submission to the ministry so and so. So this is forwarding of suspension, my lord. This letter, with this letter, my lord, this the order of suspension was handed over, my lord. Communicate to him on 7/7. So in this regard, we file a affidavit before this honorable court. This we hand over this letter on 7th of November. So it will be effect from 7th, and accordingly, his suspension allowances started from 7th of November 2022, my lord. So before that, up to some 6 months, he was paid regular salary. Man. So this was the letter, my lord. It was communicate, my lord, this and hand over, my lord. So the This honorable court, asked my lord, on when this effect will, my lord, this, our affidavit, my lord, we ended up on some so and so date, my lord, so 7, so it will be from the 7, and accordingly, everything was done, my lord, and he also received, my lord. He never raised question, this, I'm suspended, why I'm getting this, that part, I'm never out thing. And in the meantime, my lord, he filed another representation challenging the DP also. It was, my lord, withdrawn, my lord. And repeatedly, it is the third expedition, my lord. So only the delay the process, my lord. This the involvement of the money, my lord, is the 199.
See, has this court stayed the DP? It is
No,
not.
my lord, no, it was withdrawn, my lord.
No. So then why you are raising that he's done it for the purpose of delaying? He's not delaying
No,
it.
in thereafter, my lord, he filed another petition, my lord, sending
No,
the input
maybe-
officer, my lord.
Maybe every day he has a right to file a petition.
Yes, my lord.
And he's doing it for last, say, in last 1 year,
Yes,
he has filed 210 writ petitions,
I
let us say.
yes.
But in any of the case, has any order been passed to stop your
No, my lord,
DB?
no, my lord. But this,
So go ahead.
yes, my lord, but so my humble submission before this honorable court, my lord, because this honorable court may fix it date, my lord, within 2 months, 3 months, my lord, to complete the entire in the DP, my lord. In the and accordingly, this the completion of the DP, my lord, whatever is the outcome will not, he may be silenced before this honorable court, my lord. And because of the involvement of money, my lord, and there is a telephonic, my lord, this recording is there, my lord. And the person concerned against whom this it was offered, my lord, he had no existence. This Bhutan government, my lord, informed the government of India. Such person was not there, my lord. And he is the main man, he is the director, my lord. So he was suspended, my lord. He was he was not allowed to leave also, my lord. This is the ground, my lord. It was his leave application was placed before the ministry, my lord. It was rejected. Against the rejection, the writ petition never come before this honorable court. Why rejected? Why not getting leave, my lord? So now he's saying that we are not allowed. If he is agree with the action of the Union of India, he may prefer the writ petition. But
No, these are not
Yes.
these are not desirable. You see, you can't expect the employee to come to court every time for everything. And then again, you will take the plea that yes, even for leave, he has filed a writ petition.
No, my lord, but his
No, no.
leave was rejected, man. Now today he submitted, he was not
He's from his,
allowed to
he's
go, my lord.
showing it bias because otherwise if.
My lord, the involvement of the money, my lord, is 199 crores, my lord, the Bhutan
That's a
project,
very
my lord,
false
this is
statement,
the main, my lord.
The whole-
And there's a
So,
telephonic
every-
recording, my lord, my lord, telephonic recording, my lord, everything is there, my lord. Now the DP is started, my lord. So it will take within 1 or 2 months, my lord. Everything will be clear, my lord. So at this stage, my humble before this honorable court, my lord, because this is public money, my lord, this and there is some, my lord, this something is because of getting this link with this, my lord, this so he is suspended, my lord, DP is there, my lord. So at this stage, my lord, your lordship may not be, my lord, to interfere, my lord, because the huge amount of money of the relating to the other country, which is invested by the government of India, my lord. So in this case, my lord, the man, my lord, those are the non-existent person. It was given the contract, my lord. So far, this only, my lord, is the death of effect of the suspension order, my lord. If his calculation is right, my lord, and then only 2-3 days, my lord. It was first time, my lord, and subsequently it was extended on my lord, 25th of July, my lord. Another, my lord. This order also is not challenged, my lord. It is there, my lord. He received, my lord.
No, if the first order goes, the second order is not required to be.
Yes,
followed.
I understand. So my lordship, fix a time frame, my lord. In the meantime, my lord, everything will be completed, my lord. Because of this man, my lord, his involvement is there. Telephonic recording is there.
Where is that suspension order?
104.
104 initial, my lord. Third line, my lord, my lord, it is further ordered that during the period of this order remain in force. The headquarters of Vinay Kumar Singh so should be headquarters DGBR Guwahati. And the said officer shall not leave and the headquarters without obtaining prior permission of the competent authority. Because because of this, my lord, this order is passed, my lord. Last serial number 3, my lord. This is really the legal gratification, my lord. When his my lord is counted to 90 days, my lord, then there my lord is 4 days after my lord. And so for our my lord, it is within 90 days, my lord. If it is my lord, then the effect from 7, my lord. And his my lord, it is 29, my lord, another 4 days, my lord. In other case, we have no objection, my lord, because this is the project from the Indian government of India to the Bhutan, my lord. The relation of the country also is there, my lord. For a man, employee of the Union of India, my lord, this. So my humble submission before this honorable court, my lord. He was communicated 7th of November 2022, my lord. And forwarding also some 4th of November, my lord. It was enclosed, annexed by my lord friend itself, my lord. Annexer 13, my lord. So at this stage, my lord, this honorable court may not be interfered and may fix at least the time frame, my lord, to complete the department proceeding, my lord. This is my humble submission before this honorable.
Lordship, I forgot to point out one more fact. I actually wanted my learned friend to complete his submission as to the date of effect of that order. Now, even if we actually go by their submission, that the date of effective date of that order would run from 7/11. Then also, if they say that it is from date of receipt, even if it's from 7/11, that it would end on 5th of February. It is well within that particular review period. But then again, they have to hand me over that impugn extension order prior to that, and then only it will be effective. And I stated specifically in my rejoinder that I had received it on 12th of February. So if you go by that particular, if they go by that particular analogy, that it is from date of receipt, then also I received it on 12th, way beyond the mandatory 90 days period.
Where is that?
I have stated it on in the rejoinder, Your Lordship. Paragraph number 4B. Rejoinder dated, it was filed on 3rd of May 2023. B, reply on mail.
Para?
Para 4B. I'll just like to read out, Your Lordship, in this regard. That with regard to the statements made in paragraph number 4 of the affidavit in opposition, the contentions made by the respondents, except that are supported by documents, are categorically denied, and it is most humbly submitted. That if the analogy of the respondents are to be accepted in respect of the effective date of the suspension order dated 1/11/2022, which in the understanding of the respondents would be from date of handing over of the forces suspension order dated 7/11/2022, then the last date of expiry before 90 days of the first review would be 5/2. Now, if the said analogy of the respondents are to be accepted to the effect that the date of acceptance of the ink signed copy of the order would be the effective date of the order, then also the impugned order dated 3/2 is bad in law and hence liable to be struck down, since the ink signed copy of the aforesaid impugned order dated 3/2 was received by the petitioner only on 12/2/2023, which is much beyond the mandatory date, which in the opinion of the respondents would be 5/2/2023. So even after accepting the analogy of the respondents, that the effective date of suspension order would be 7/11/2022 instead of 1/11/2022, which the petitioner is claiming to be the effective date. The petitioner would like to further humbly state, Your Lordship, and there is a DOPT OM also, to the effect that the suspension order should specifically mention as to the effective date of that order after that rule 10.6 and 10.7 was amended. And I have annexed it in the rejoinder also. At page number 7, page number 6 at the bottom. The DOPT OM dated 12 July 2007. Internal page 6, Your Lordship. I'm sorry, I didn't mention the running page number. Last page, Your Lordship. Consequent upon this amendment, it would henceforth be necessary to specifically indicate in the order of the suspension the effective date of suspension. Here in the impugned order, it is with immediate effect at page number 104. And it would run from 1/11. That is my humble submission.
My lord, this word question of receipt, my lord. The communicate and receipt, there's two things, my lord. Here, my lord, he says we receive, my lord. The other case, Punjab case, my lord, this is a we receive, my lord. Receive point, my lord, his part, my lord. So he particular time he may not receive, my lord. Subsequent time also receive, my lord. The communication the date is there, my lord. So that is, my lord, the Punjab case says, my lord, when he he may not receive also, my lord. This is this point, my lord, does not attract his no benefit, my lord. His receipt, my lord, is may not be at time also, my lord. So when he was communicated, that part, my lord. So my lord, humble submission, time frame may be given, my lord, we will complete this DP, my lord. Because this my lord, relating to huge corruption, my lord. If he's my lord, nothing is there, my lord, he will free, my lord, within one from November, he's there, my lord, another 2 months, my lord, he will be there, my lord. Even he was offered the my lord, that work order to the genuine person, that also different, my lord. Not the existing person, the government of the Bhutan, my lord.
I'm not on merit, Your Lordship. If I have to
Yes,
go on
I'm
merit,
saying,
then
my lord, because
this would
these-
highly
these-
prejudice
No,
me.
those things are not here.
Yes, my lord.
Those questions are not
I
here.
In your-
understand,
in your
I understand,
affidavit also it's
so,
not
my lord,
there.
so our problem, he is here, my lord, and they say your lordship definite time frame, my lord, we complete everything, my lord, because he's from the November, my lord, this under, my lord, suspension, my lord. Another 1 month or 45 days, if we'll complete everything. At this stage, my lord, if it is interfered, my lord, it may be DP also may not properly, my lord.
Examination. They write the names, DP Para and SK Bedi.
Yeah.
Just give me the dates again, first review,
First is 1/11/2022. And the impugned order, extension order is 3/2/2023,
no, first review is 111.
1/11.
First review, my lord, first, my lord, issuance of the suspension order 111.
No, first review,
Review, my lord,
First
third
review,
of
three-
February.
3/2/2023.
And second review, my lord, 25th.
3 to 2022,
Yes, my lord.
And the
Third
3 to
February
2022,
23.
23, your lord,
23. It was served to you when?
on 12th of February, 2023.
No, receive, my lord, not served, my lord.
That
He
is,
received, my lord, receive one, my lord.
Decision served same thing.
My lord, served is different, my lord, if it's because he received, my lord, served is different. My lord. He received, my lord, on third, on 12th, my lord.
I'm not getting your lordship, because 7/11, they are sticking to that I have received it, I have been served. And 12, they are not. I'm
My lord, so
totally
for that
perplexed.
instruction, I'll
I
take,
don't
my
know.
lord, if required, my lord, I'll take it, sir. When he, my lord, he was, actually, my lord, it was handover, my lord.
Lordship,
Because my, if tomorrow also, you, I can provide that instruction.
I don't know, you give, by the time I decided.
And second extension, my lord, 25th July, my lord, 2020.
No, 25th July is not questioning.
Yes, yes.
not in question.
Number 9.
My lord, in this case, my lord, my brother, they are also appearing, my lord.
In this matter. Yes, what is the stand?
Lordship, my stand is, Lordship, the person concerned was earlier on deputation in the NHIDCL, and during that tenure of NHIDCL, Lordship, that was corruption was held, Lordship. And thereafter, the person was reverted back to the parent department, that is BRO. So now DP is going on in the department of BRO. So, Lordship, we have no role, Lordship, now.
And that is my specific stand also. I am in no position to interfere with the interfere with the evidence, because it was in NHIDCL when I was on deputation.
Lordship,
And
in
right
this
now
regard,
I'm back
Lordship,
in my parent department.
Lordship, in this regard, Union of India has filed affidavit, Lordship, that may be dated our stand also, Lordship. So I'm supporting the argument led by Union of India, Lordship, that may be referred, Lordship.
What is that? No charges are there.
Memorandum charges, they have annexed in the affidavit in opposition.
And what is the second writ petition for? There's one 7478.
It was against suspension order. Challenging suspension order.
Suspension order, and also they had a prayer that for the departmental promotion committee formed by the UPSC, seal cover procedure should not be resorted to. But in the meantime, it was a meeting was already conducted, and we have kept his recommendation the seal cover.
Lordship, the first writ petition was with regards to challenging the original suspension order on the ground of biasness and mala fide intent. I'm not actually, because since the disciplinary proceedings have actually started, that would actually prejudice me at this juncture if I have to press for it. Because they will again take the stand, whatever is taken here in the writ petition. I prefer to take the stand in the disciplinary proceedings whenever it is complete.
So what to do with this writ petition?
Your lordship may close it, your lordship,
7478 or 2022?
747,
This you want to close it
yes,
without adjudication?
without adjudication.
Allow you to reserve your what do you call, to take an appropriate stand in the DP.
DP, since memorandum charges has been issued on 10th March 2023. And they have annexed it at page number 147 of the affidavit in opposition.
So it's very clear.
In WPC number
7478,
1074.
7478 or 2022. Yeah. Mr. DP, Mr. D. Bora, learned counsel for the petitioner. Also heard Mr. S.K. Medhi, learned CEC appearing for in this in the 7478.
Yes, my lord. I am appearing both the cases, my lord.
No, 7478.
Yes.
You are
Yes, sir. 1, 2, 3, 4, my lord.
1 to 4. And for others,
5 and 6, 5.
Sarkit Algar for 5 and 6. You are also there.
I am for 7.
Mr. Dr. A. Tudi for Farmer 7. Next paragraph. It is submitted by the London Council for the petitioner that during the pendency of this petition, comma, the authorities of Border Road Organization this charge sheet is page 140.
147, annexure O of the affidavit in opposition
Oh, okay.
filed by the Union of India.
Okay, the Ministry of Defense has issued a memorandum of charges dated 10/3/2023. Accordingly, it is submitted that in view of this subsequent development, comma, the petitioner has instructed not to press this petition, comma, with liberty to the petitioner to take appropriate defense in the Department of Proceeding. Next paragraph. Prayer is allowed. Matters is dismissed on as not pressed.
With liberty to challenge them later on.
Huh?
With liberty to challenge, your lordship not.
No, it's not legal. So the withdrawal is without prejudice to the rights of the petitioner in the departmental proceedings. Correct, Mr. Bara?
Yes, sir.
Without prejudice to your rights in the
Without
general
prejudice, without
proceedings. Okay.
I'm only agreed with the suspension order extension.
My lord, so far, my lord, there is a receipt of this review order, my lord, third
Just
of
a moment,
February.
just a moment.
One so far, my lord, receive of the my lord, the review order, my lord. Third of February itself, he received, my lord. There is a, I've, yes, my lord, it is there, my lord. I've,
Then records being put.
yes, my lord, it is there, my lord. It is sent from the Delhi, my lord, right, just now, my lord. My lord, 3rd of February, my lord, he received, my lord. It is there, my lord.
Then you produce it.
Yes, my lord.
Because it will be material.
Yes, my lord. So, my lord, the photocopy or the original, my original.
No,
from
no,
the-
you'll have to file an affidavit, bring it on record. Somebody
Yes, ma'am.
must
Yes,
take
ma'am.
responsibility of
Yes,
that.
my lord, yes,
The ink
statement.
signed copy when I received it.
yes, my lord, it is there, my lord.
Ink signed copy.
It is there, my lord.
That is very important.
It is there, my lord.
Okay. So. One of the submissions made by the counsel for the petitioner was to the effect that the order of first review was issued on first review of the suspension of the petitioner was issued on 3/2/2023.
Yes.
Which was served on him on 12/2/2023. First of accordingly, it is submitted that even if the initial order of suspension is found sustainable, the order of first review having been served beyond the period of subsequent 90 days is bad in law, which initiates the suspension. First of next paragraph. Per contra, in respect of the said submissions, the learned CEC has submitted that he has received instructions on his mobile, specifically saying that, specifically stating that the order of first review dated, first review of suspension dated 3/2/2023 was communicated to the petitioner.
And
On-
receipt, my lord. He also received
It was received by the petitioner
on third.
on 3/2/2023. And accordingly, he prays for some more time to file an affidavit to bring it on record.
Yes.
So stop. Here is allowed. The respondent and the officer shall file an additional affidavit to bring on record any stand they intend to take in this petition, specifically with regard to service of the notice of first review of order of suspension dated 3/2/2023.
Lordship made note, ink signed copy, ink signed copy. He received it.
No, whatever they want to
If
produce,
he-
you take your,
if he has
take your
received it,
stand.
Because if the analogy goes that I received the ink signed copy
No,
on
no.
7. That is.
No, it may be signed, it may not be signed,
No,
but
it is signed.
they'll show communication.
They have communicated, maybe. They have
That
communicated.
question
May-
may arise.
But the ink signed copy, because
no.
the seventh on seventh of
What is there, you
November,
take your defense on that day, on
Yes,
that,
yes,
on
yes.
that petition.
because the seventh of November, which they are actually claiming, I received the ink signed copy on seventh of November.
Yes.
That's why they are counting it from that particular day.
Here also, my lord, shows. my
Here
lord,
also I have to receive it, the signed, ink signed copy.
No, it's okay, but
On-
let them produce a document, then
Yes,
you take a stand,
Yes,
whatever they have to take.
Yes, yes. Some date may be fixed, your lordship.
When,
my lord, 11th of this month, my lord.
It's a motion day, your lordship, tenth.
On 10th
no,
also, my lord.
let it come on motion, because you'll have to file an affidavit, you'll have to, you'll respond it to it.
10 also, your lordship, 10 month.
This, according to the matter stands deferred today, based on 11/8/2023. The affidavit shall be filed at least 2 days prior to the next date of listing.
Let's keep part.
I'm not giving it further.
Yes.
Highly appreciated.
Hmm? Dr. Todi, we'll hear you on the next date. We'll hear you on the next date.
Yes.
Right.
The information is coming. Madam. In the meantime, may I just draw your lordship attention to page 45.
That is the only point Upen Das.
Yes, ma'am.
He gets the benefit of Upen Das.
Yes, my lord. That order, in terms of that order, my lord, the fresh order has been passed by this honorable court, my lord, single bench of this honorable court. In fact, my I think I included it. Yes, madam. Because on last occasion, it was my proposal that his case may be considered in terms of this order, my lord, the fresh order, the Jodumoni Nath, my lord.
My lord, Upendas, para 22 lordship is kindly.
This order has been passed on the basis of the ratio laid down in the Upendas, my lord. So on last occasion, it was my proposal that, my lord, his case may also be disposed of in terms of this order, my lord.
Para 22, my lord, Upendas.
But Mr. J. Patwari, law and counsel for the petitioners, as well as Mr. D.P. Boral, and standing counsel for the health department, appearing for all the respondents.
My lord. My lord, except two, my lord. Two is finance department, my lord. 1, 3, 4, 5, and 6, my lord.
1, 3, 4, 5, and 6, and finance would be Mr. A. Salia.
Yes, Alia may be reported.
Mr. A. Salia, standing counsel for finance department, appearing for respondent number 2. Next para. The petitioners claim that they were appointed as daily wage, on daily wage basis by the superintendent of the Assam Medical College, Dibrugarh.
Yeah.
for rendering various services in the Assam Medical College and Hospital, Dibrugarh. Stop. The petitioners have approached this court seeking a direction upon the respondent authorities to pay them monthly pay at the pay band of the monthly pay of pay band 1 give a dash then rupees 12,000 dash 37500 plus great pay of rupees 3900. Full stop. It is not in dispute that the petitioners are being paid on daily wage basis.
A fixed pay of 9,000.
As a
Fixed pay of
fixed pay of 9,000. Full stop. The learned counsel for the petitioners has invoked the principle of equal work, equal pay. And by placing reliance on the decision of the division bench of this court in the case of State of Assam versus Upendas and others within 2020 within bracket 5 bracket close GLT 605. I wish this court, while holding that the petitioners the respondents therein were not entitled for regularization of services with consequential benefits. Directed the state government to pay minimum of the pay scale to the muster roll workers, work charge workers, and similarly placed employees working since last more than 10 years, within bracket, not in sanctioned post, bracket closed, with effect from 1/8/2017. Next, the Learned Counsel for the petitioners has submitted that in the present case in hand, the petitioners have served the Assam Medical College and Hospital, Dibrugarh for more than 10 years.
Yes, but annex the appointment letters in our additional affidavit of all the petitioners.
Okay, for more than 10 years. Full stop. Yes. The Learned Counsel for the petitioner has also referred to
Para 23.
another decision by the coordinate bench of this court in the case of Jadumoni, JADUMONI, Nath, and others versus State of Assam and others, WPC 7711 of 2016. Decided on
10/11/2022.
10/11,
2022.
2022.
Para relevant portion, para 23, my lord. Because the Dudumani Nath case is almost similar to the petitioner, my lord. Because there was a issue whether, my lord, in the case of Upendas, it is said that when the person is appointed by the government. So there was an issue in the case of Jodumani Nath that the person,
Appointed by hospital management committee.
yes, my lord.
In this case, it is not there.
No, no. So even if otherwise, Jodumani Nath covers their case, my lord. Para 23, my lord.
Wherein set of similarly situated employees were also granted the benefit flowing from the decision of this court in the case of Upendas within the case Supra. Next para. On facts, comma, the contention of the petitioner is not opposed by the runner. Standing counsel for the respondents. Full stop. Therefore, comma, it is not disputed by the state that the petitioners are serving as wage earners.
Yes, in different
Wage-
capacity, IRs, ward boys.
Wage earners in Assam Medical College, Dibrugarh, in various capacities like,
IRs, ward boys, chowkidar.
okay, like ward boys,
Lordship will kindly see para. Para 2, my lord, of the petition at page 8. Paragraph 2.
as ward boy, AYAH, comma, peon chowkidar, female sweeper, etc.
Lordship
And it is also not in dispute that the petitioners are being paid wages as per so, fixed pay of rupees 9,000 per month. Full stop. Next, accordingly, comma, in view of the ratio laid down in the two cases of Upendas and Supra and Jadumani Nath within the case Supra, what is the considered opinion that the privilege of being given a minimum scale of pay to the scale of pay should be extended to the petitioners who are rendering services in Assam Medical College and Hospital, who have projected to have been employed by the superintendent of the said hospital. Full stop. Next, accordingly, comma,
My lord, the
The-
last para of the Jodumani Nath, that
I'm
may
saying
be.
that.
No, my lord, here, my lord, in this case.
No, I'm not saying that the Jadumani Nath is already there. I
yes.
do I have to quote it?
No, my lord, but that has to be considered, my lord, well, because my lord, in this case, I have not filed affidavit. I have not obtained instruction. So I am on the basis that the petitioners are given the liberty to submit.
No,
in
that I'm
detail.
making. Representation will be made by the.
Yes, my lord, that part. And the authority will consider and pass decide the matter within a specified time period. Because otherwise, my lord, I have not received any instruction or any file any affidavit.
If submitted a resolution.
My lord, I'm not disputing, but that's why I wanted to draw your lordship attention to page 45. We have already submitted our representation and our case was already forwarded to the government, my lord. Page 45 of the representation.
Because I am agreeing to the disposal in terms of the para 23 of the Jodumani Nath, my lord.
Page 45.
Page 45. This is a letter from the superintendent to the DME, my lord. May I just read it? With reference to above, I have the honor to bring to your kind notice the following facts about government wage earners at MCA deliver under the establishment of.
No, this is not a representation. This is their forwarding.
No,
of
we have
their
already
proposal.
represented, that's why the superintendent forwarded. my
So
lord.
you send a fresh one. They
We'll
will
submit a
consider
fresh
this
one.
or the fresh one.
Yes, my lord, that will be better, man.
Yes, no, we can submit a fresh one also within a time frame they can dispose of our representation.
And it just had, the land council, the petitioner has referred to a forwarding letter bearing number MCH oblique 2021/2539 dated 2/2021
The penalty must pay.
within bracket annexure 11. The project that the superintendent of Assam Medical College and Hospital, Dibrugarh, has already submitted the proposal to the Director of Medical Education Assam to move the government for enhancement of the salary of the of 19 numbers of wage earners under the pay band under pay band -1 with grade pay of rupees 3,900 along with the list of the 19 wage earners.
Page 46.
Just, accordingly,
All the 19 have read petition as well, but at page 46, the list is given.
accordingly, in view of the ratio laid down in the case of Upendra Subra and Jadumani Nath Subra, the court is of the considered opinion that the petitioners would be entitled to the benefit flowing out of those cases. So accordingly, the court is inclined to dispose of this rate petition. By giving liberty to the petitioners to submit individual representations to the superintendent of Assam Medical College and Hospital, Dibrugarh, with regard to their claim for payment of minimum scale of pay. Such a representation shall be submitted within a period of
We will file within a period of 2 weeks.
within a period of 2 weeks. And the superintendent of Assam Medical College, Dibrugarh, Medical College and Hospital, Dibrugarh, shall forward the same to whom?
To the Director of
To
Medical.
the Director of
Education.
Medical Education, Assam. So as to enable the concerned respondent authorities in the Directorate of Medical Education, Assam, the finance within bracket EC-2 bracket close department and the Health and Family Welfare Department, Government of Assam, to take an appropriate decision either on the said representations or in respect of the herein before referred letter number MCH /2021/2539 dated 2/12/2021 by the Superintendent of Medical College and Hospital, Dibrugarh, addressed to the Director of Medical Education, Assam, within bracket annexure 11, within a outer period of 3 months from the date of submission of a certified copy of this order to the Superintendent of Assam Medical College and Hospital, Dibrugarh.
Yes.
So either in this representation, this letter which is already there on record,
Yes, my
or
lord.
on the press representation.
We'll do it.
Next paragraph. Is the Repressions up to the extent as indicated above.
Deeply obliged, my lord.
Obliged, my lord.
Those will be no others to cost.
Yeah, the lordship. As per last order dated 15/5/2020, the state has been supposed to file the affidavit, not yet filed the affidavit. But we need 10 more days, my lord, we'll file our affidavit, my lord. We have already
What
received
about-
our instructions, my lord.
What about the private respondents? They have not appeared.
They have not appeared.
Both sides are duly represented. Mr.
B Das, my lord, on behalf of D. Gogoi, the standing counsel for the forest.
Mr. B. Das. The council appearing on behalf of Mr.
D. Gogoi, my lord.
D. Gogoi, standing counsel for Forest Department. Praise for and is granted 10 days time as a last chance to file affidavit in opposition in the matter. Affidavit in opposition shall be filed within 11/8/2023. List on 16/8/2023.
Obliged. Highly obliged.
11 for hearing.
This is an application under section 11 of the Arbitration Act. my lord. I'm praying for appointment of an arbitrator by this honorable court.
What is the nature of dispute?
But the dispute is regarding a partnership deed which has been entered between the petitioner and the respondent, my lord. If I may take my lord to page number 22.
22.
My lord has it. This is the
Where
partnership.
is
deed.
the arbitration clause?
My lord, the arbitration clause, my lord, is at page number. Starts from page number 25, my lord, internal page number 3. That if any dispute arose between the parties, they will try to their best to settle the dispute amicably, and in the event of non-settlement of the dispute amicably, then they will refer to the arbitration jointly appointed by them, and decision of the arbitrator shall be final and binding. Subsequently, what has happened, my lord, we have opened a center for collection of the blood, which was provided by this particular deed as well. In the paragraph number 20, page number 24, my lord. We have opened a lab by the name of Progoti. And after expiry of a particular period, my lord, what he has done, he has violated the clause of this particular agreement, and he has opened another center in the same place under the name of Progoti by only changing a name in it. My lord. There are dues, there are loans which I have procured in my name from the bank, and he has sidelined all those, my lord, and he has opened this particular name by only changing a particular name. If I may take my lord to page number 27, the letter which I have written to them, my lord.
You have not filed a affidavit in opposition.
We have filed.
You filed it.
We have filed it on 5th of September 2022.
The crux of the issue is very limited before this honorable court. And I have written an letter to him, my lord, to the respondent, appointing an arbitrator of this honorable court. And in his reply, which was not furnished to me, but it has been given in the reply, my lord, in their affidavit in opposition, they have stated that as the agreement was at Dibrugarh, a person of Dibrugarh should be appointed. That is the crux of the issue, my lord. In their reply, it is very apparent.
Yes.
Lords, my arguments would be twofold. Firstly, my lords, my argument would be that there is no valid arbitration agreement as on date. So in terms of section 6A, 11, subsection 6A of section 11 of the Arbitration and Conciliation Act, plus my lords will have to decide whether there is an arbitration agreement valid. If there is no arbitration agreement valid, my lords will not put us to and proceed as.
What according to you is a valid arbitration agreement?
My lords,
What according to you is a valid arbitration agreement?
my lords will take up the partnership deed for a moment. please. It is at page 22, my lords. If my lord comes to page 24, in the third subpara, and whereas the partners desire to start one authorized sample collection center of Dr. Lal Path Labs Private Limited, New Delhi, in partnership. So this arbitration, this agreement, partnership deed, was executed for a specific purpose of opening a sample collection center. In pursuance to this, an agreement was entered between the first party, the petitioner hearing, and Dr. Lal Path Labs. That is at page, my lords, 22 or no, my lords, 17. The relevant portion is on page 17, my lords. It starts at page 9. As my lords quoted.
Yes, yes, please continue.
This is an agreement between Dr. Lal Path Labs and the petitioner hearing for opening a sample collection center. Plus, if Malas comes to page 17, clause 9 thereof.
Yes.
Clause 9 reads as thus, my lord. This agreement will be valid for a period of 5 calendar years from the date of its signing. Upon expiry, agreement may be renewed for an additional period of 5 years with mutual consent. The second party shall intimate its intention so and so, so and so. Upon failure of the second party to exercise such option to renew, the first party shall be entitled to enter into agreement with any other party. So the date of this agreement was 6th of April 2010. Upon expiry of 5 years, this agreement was not renewed. So this agreement expired on 5th of April 2015. After that, after more than 1.5 years, I entered into a partnership agreement with Dr. Lal Path Labs with under the name of my sole proprietorship. That is not a partnership. What he is now claiming is that he wants a share of the profits in my proprietorship. So this agreement had expired in 2015 itself. As on today, there is no valid partnership deed. So when there is no valid partnership deed, the question of any arbitration clause that was in that partnership deed, it has also expired with that particular agreement with the partnership deed. So there is no question of sending us to arbitration also.
Are you arguing a correct proposition of law?
Yes,
Partnership Act.
If my lords takes up the Arbitration and Conciliation Act rules, sections,
Yes,
subsection 6A of section 11, my lords.
yes, continue.
The Supreme Court, or as the case may be, the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order of any court, confine to the examination of the existence of an arbitration agreement. Plus, may I give a little background of this notes? This section 6A was incorporated by an amendment in 2015, my lords. Prior to that, my lords, in 2009, there was a judgment of the Supreme Court which said that the High Court,
Partnership.
I'm reading Arbitration and Conciliation Act. In 2009, there was a judgment of the Supreme Court which said that while exercising powers under section 11, at the pre-referral stage, the High Court can look into the arbitrability of the dispute and as well as on the existence of the agreement. So in response to that, the legislature included this particular section, section 6A, which confined the jurisdiction of your lordships only with regard to the existence of the agreement. The arbitrability of dispute was done away with. Because subsequently, there is another.
Yes, please continue.
Subsequent to this, there are judgments of the Honorable Supreme Court of 2023 itself. I have brought them. Lords. They say that while referring at the pre-referral stage, your lordships should look into the validity of an arbitral agreement.
Okay, you come to your agreement. Where is the date of expiry of this partnership? What a tenure of the partnership agreement? Where is that?
There is not. But
There is no.
regard to that, I would like to make a submission. Lords. This particular partnership agreement was made for a particular specific work. Work means it was.
That's
Make-
why I asked you
Yes.
whether you are making a sound legal argument.
Yes.
Your submissions, whether they are correct legal propositions.
Yes.
It's not there.
What, with all due respect, you'll have to refer to chapter 6 of the partnership.
No.
Partnership Act,
He is right.
chapter 6 of the partnership act. Rather than the arbitration.
So if the tenure of the agreement is not there, it will be a partnership at will.
Because I would
And
like to,
partnership at will be terminable only when you issue a notice. And that is the effective date of
I would like to take
termination.
first to section 42 of the Partnership Act, which speaks that dissolution on happening of certain contingencies.
42.
42.
Yes.
So section 42 is thus dissolution on the happening of certain contingencies. Subject to contract between the parties, a firm is dissolved. A, if constituted for a fixed term, we are concerned with B, my lords. If constituted to carry out one or more adventures or undertaking by the completion thereof. So this partnership deed was entered to carry out the undertaking of that particular sample collection center that was open under a partnership deed. So when the partnership, the sample collection center, the term of the sample collection center had expired in 2015, there is no existing sample collection center in the name of Pragati. I have a sample collection center that is my sole proprietorship, but under the partnership agreement, there is no sample collection center. So in my humble understanding, my lord, in terms of subsection B of section 42, this partnership is expired. My lord.
Yeah, the name of your agency is also Pragati.
It is, there is a change in the spelling words. It is PROGO. The earlier one was PRAGA. May I refer a judgment of the Honorable Supreme Court with regard to the existence of a arbitration agreement?
This is a very recent judgment, Malad. If Malad reads para 2, Malad, the issue involved in the present appeals is as such in a very narrow compass, namely pre-referral jurisdiction of the court under section 11(6) of the Arbitration and Conciliation Amendment Act 2015. Thereafter, if Malad, if we skip the facts and directly come to para 13, Malad. Citation to give 2023 SCC online, SC 620.
SCC online.
SC 620. So there are 13 marks. Third, the short question which is posed for the consideration of this court is jurisdiction of the referral court at pre-referral stage when the issue with respect to the existence and validity of an arbitration agreement is raised. While considering the aforesaid issue, section 11(6)(a) of the Arbitration Act, which has been added through Arbitration and Conciliation Amendment Act 2015, is required to be read, which reads as follows. I'm skipping that, I have already read that. Then article para 15 words. Thus, post Arbitration and Conciliation Amendment Act 2015, the jurisdiction of the court under section 11(6) of the Act is limited to examining whether an arbitration agreement exists between the parties, nothing more, nothing less. Thus, as per section 11(6)(a) of the Act, it is the duty cast upon the referral court to consider the dispute issue with respect to the existence of an arbitration agreement. At this stage, it is required to be noted that as per the settled position of law, pre-referral jurisdiction of the court under section 11(6) of the Arbitration Act is very narrow and inheres two inquiries. The primary inquiry is about the existence of the validity of an arbitration agreement, which also includes an inquiry as to the parties to the agreement and the applicant's privity to the said agreement. The second matter that is not important to us, the second matter requires a thorough examination by the referral court. The second inquiry that may arise at the referral stage is with respect to the non-arbitrability dispute. That is not our case, Malad. Both are different and distinct. Now, Malad, this is important. So far as the first issue with respect to the existence and validity of an arbitration agreement is concerned, as the same goes to the root of the matter, the same has to be conclusively decided by the referral court at the referral stage itself. Now, Malad, it skips certain one. Takes up the last sentence of that particular page. It begins with however, a sentence beginning with however in that particular paragraph. However, so far as the dispute with respect to the existence and validity of an arbitration agreement is concerned, and when the same is raised at pre-referral stage, the referral court has to decide the said issue conclusively and finally, and should not leave the said issue to be determined by the arbitral tribunal. The reason is that the issue with respect to the existence and validity of an arbitration agreement goes to the root of the matter. As observed by the Constitutional Bench in so-and-so, an agreement, sans an agreement, there cannot be any reference to arbitration. In the said decision of this court has also specifically observed and held that intention behind the insertion of section 11(6)(a) in the Act was to confine the court acting under section 11 to examine and ascertain about the existence of an arbitration agreement. We are of the opinion that therefore, if the dispute issue with respect to the existence and validity of an arbitration agreement is not conclusively and finally decided by the referral court while exercising the pre-referral jurisdiction under section is 11(6) and it is left to the arbitral tribunal, it will be contrary to section 11(6)(a) of the Arbitration Act. It is the duty of the referral court to decide the said issue first conclusively to protect the parties from being forced to arbitrate when there does not exist any arbitration agreement and or when there is no valid arbitration agreement. This is my precise submission, Lord. There is no valid arbitration agreement as on today. So, my Lord will not send this matter to arbitration and put my client to undue hardship, my Lord.
Yes, what is your response, Mr. Sainsbury?
My lord, if partnership open to close the 42B. But before that, may I please take my lord to the letter which I have written them to them, my lord, which is as page number 30 of my petition. The last paragraph, page number 31. That on 27/11/2020, I had written a letter to you for amicable settlement of the dispute which has cropped up between us pertaining to the partnership deed duly entered between us by way, but you have failed to come forward and settle the dispute. Therefore, now on being constrained by your act, I am hereby invoking the arbitration clause of partnership deed dated so and so, and I hereby give to you notice of appointment of Sri so and so, Advocate, Guwahati High Court, as the sole arbitrator for resolution of the dispute and difference arising out of the partnership deed dated so and so, executed by and between us. You are hereby requested to provide your consent within a period of 30 days from the date of receipt of this notice, failing which I shall be constrained to seek remedy for appointment of arbitrator through appointment appropriate court of law. Now, my lord, this is the application which I have given him. And the reply, my lord, will see in his affidavit in opposition, page number starts with page number 60, my lord. I'm sorry, 62, my lord.
52,
62, my lord.
62. Yes,
My lord has it. The last paragraph again, my lord, of this page 63. Regarding appointment of Sri so and so advocate Guwahati High Court as the sole arbitrator of resolution of dispute and differences, I had to say that I have objection in the appointment of the said arbitrator, as I shall not be able to go to Guwahati for arbitration matter. And moreover, in the pandemic time, it will not be possible for on my part to travel to Guwahati, but better you may appoint an arbitrator locally in Dibrugarh or communicate me personally in regard, as I am always willing to sit and settle the matter with you. So, my lord, my learned friend, what he is arguing and the reply which has been given to me is completely contradictory. In this particular reply, he is accepting, but his only contention is that, no, I won't be coming to Guwahati. You appoint an arbitrator at Dibrugarh and accordingly I will participate in the arbitration process. So I ask a question to myself, whether we'll get advice by these statements given by him in the court or the pleadings by. Certainly the pleadings by.
These are not only my statements, these facts have been stated.
let him complete.
This has been statement given by him. His only contention is as regard to that he is not willing to come to Guwahati. He is ready to participate in the arbitration process as Dibrugarh. He has accepted it. Now, my lord, as regard to the partnership deed, this is a registered partnership deed, my lord, which has been entered, duly entered, and merely drawing a reference from a particular section and giving a different angle to it is altogether, that is not permissible, my lord, with all due respect. Because the issue before this honorable court, which I'll be raising before the tribunal, is regard to an existing loan, which I have taken for running of this particular firm. Where will the loan go, my lord? It is admitted fact that this partnership deed was entered for running of this particular the blood connection
But
center.
that can't be a dispute with regard to the partnership. You say that you have taken a loan.
I have taken a loan, my lord.
So you see the partnership has not taken a loan.
Partnership has not taken a loan. I have taken a loan, and in fact, the agreement which has been referred to him, is between me and the Lal Pet Lab. And now he is using my name, only changing a single word in it. It's single A to O, and he is running his own center at the same premises. And moreover, using the same equipments which I have purchased, procuring that particular loan. That issues are a matter of facts that need to be decided by the tribunal. He can raise all these contentions before the tribunal. Ultimately, my lord, the sum and substance of the partnership deed has to be considered, has to be taken into consideration. It was open for running a blood collection center by executing a deed with Lal Pet Lab. That is specifically there in the name of Pragati. So 42B, my lord, doesn't come in way, my lord, in appointing an arbitrator in this particular case. The issue still remains, my lord, wherein I am repaying the loans taken in the name of that particular center which existed. So cause of action as of this day still survives. My equipments are still used by him.
And that is where evidence need to be adduced and an appropriate, my lord, adjudication is to be done by the arbitration tribunal.
In your affidavit in opposition, where you have taken a stand that this agreement has, what do you call it, lapsed by efflux of time.
Yes, please.
Where is your statement in your affidavit in opposition?
Now we'll take up page 4 of my affidavit in opposition.
Page 4.
Page 4 of my affidavit in opposition. There are capital E. Capital E. On the first line itself, that on 5/4/2015, the term of the agreement between Dr. Lal Patlevs and the petitioner had expired.
Yes, my lord, that is not disputed by me.
No.
It is
Malas goes on to read that paragraph. After expiry of the said agreement, the petitioner did not contact the respondent for renewing the same and enter into a fresh agreement with so and so. It is pertinent to state herein that the partnership deed that was entered between the parties was specific to the operation of the sample collection center. And since the agreement for operation of the sample collection center had expired, the partnership deed also became invalid. That is my specifically clear case.
Where is that tenure in your this Lalpat agreement? Where is that tenure?
My lord,
3
take up
years.
Page 17 of his writ petition, of his application also.
17.
Clause 9 thereof.
Heard. Mr. R. Senswell, learned counsel for the petitioner. And Mr. S. Biswakarma, learned counsel for the respondents. Next, para. By filing this application under section 11 of the Arbitration and Conciliation Act from the petitioner has paid for appointment of a arbitrator to adjudicate upon the disputes arising out of the partnership business under the partnership business, which was based on the partnership deed dated 7/4/2010, registered as deed number. What is the number? 208. 1208. What is the number?
Deed number 204, madam. 204.
It will not be 204. Or 204. For the office of the senior sub registrar Dibrugad, which is a partnership deed containing arbitration clause, which reads as under Roman 13, that if any dispute arose between the parties, they will try to their best to settle the dispute amicably, and in the event of non-settlement of dispute amicably, they will, then will refer to arbitration jointly appointed by them, and the decision of the arbitrator shall be final and binding. Extra. The case presented by the petitioner is that he had entered into an agreement dated 6/4/2010 with Dr. Lal Path Lab Private Limited, Dr. Lal PATH LAB, one word, Private Limited, New Delhi, for opening of a sample collection center under the name and style of Mrs. Pragati, PRAGATI, situated at AMC Road, opposite Sanjeevani Hospital, PS Jalan Nagar, Dibrugarh 786001. First of all, it is posited that after it's reflected that the sample collection center agreement was entered into between the petitioner and Dr. Lal Path Labs Private Limited on 6/4/2010. Full stop. Pursuant to this agreement, comma, a partnership deed dated 7/4/2010 was entered into between the petitioner and the respondent. As per the narration contained in the said partnership deed, it is provided that the partners were desiring partners had desired to start an authorized sample collection center of Dr. Lal Path Lab Private Limited, New Delhi, in partnership. Full stop. In course of time, partnership dispute arose between the petitioner and the respondent, for which the petitioner had issued a notice dated 27/11/2020. Amongst other, stating that the respondent had started his own sample collection center for Dr. Lal Path Lab under the name and style of Progoti, PROGOTI. And in exclusion of the petitioner, the center is now being now run by the respondent. This was followed by issuance of a notice under section 11 of the Arbitration and Conciliation Act, dated 10/5/2021. When it is alleged, amongst others, that the petitioner had taken a huge loan in his individual capacity for running of the said sample collection center. And that the respondent had opened up a new center at the same location by retaining all his equipment without bringing the partnership to an end. And that the center is now being run with change of spelling from Pragati, Pragati, TO2, Pragati, Progoti. Accordingly, the arbitration clause in the agreement, in the partnership agreement, was invoked by suggesting the appointment of a lawyer named therein as the sole arbitrator. Full stop. The learned counsel for the petitioner has submitted that the partnership agreement is valid and subsisting, and that the arbitration clause contained in this said agreement was alive, and therefore the parties be relegated to settlement of dispute through arbitration. Next paragraph. Per contra, comma, the learned counsel for the respondent has referred to the provisions of the sample collection agreement dated 6/4/2010 between the petitioner and the and Dr. Lal Path Labs Private Limited. And it is submitted that as per clause 9 of the said agreement, comma, the said agency agreement was valid for a period of 5 calendar years from the date of signing, and which was required to be renewed for a further term with mutual consent. So it is submitted that as per the narration contained in the arbitration agreement, comma, the partnership was for a specific purpose to start a authorized sample collection center. So hence, comma, it is submitted that on completion of the tenure of the agreement dated 6/4/2010, 2010, the provisions of section 42 within bracket B of the Partnership Act, 1932 would apply, which, by which the partnership between the parties are deemed to have been dissolved if dissolved because the partnership was constituted to carry out one particular business of sample collection center of Dr. Lal Path Lab, which stood terminated on completion of the tenure of the agreement. Hence, it is submitted that the partnership is deemed to have been dissolved. And therefore, the arbitration clause would not be enforceable. Full stop. In support of his submissions that the arbitrability of the dispute should be adjudicated first.
My argument was regard to the validity of the arbitration agreement. Has to be
The
decided.
validity of the argument has to be adjudicated first, comma. The learned counsel for the petitioner has referred to the decision of the Supreme Court of India in the case of Magic, MAGIC, Magic IEYE Developers Private Limited versus Green Edge EDG Infrastructure Private Limited and others, 2023, SCC Online, SC620. First of para 16 on which Reliance's place is extracted below. In the considered opinion of the court, notwithstanding whether the partnership agreement between the petitioner and the respondent exists or not, it is well settled in arbitration jurisprudence that an arbitration agreement is a distinct and separate agreement which is independent from the substantive commercial contract in which it is embedded. First of all, it would be appropriate to
If I may, my lord.
Where is this
Where?
11A? Give me the 11A. Six A.
6A, my lords.
6A you are referring to?
Yes, ma'am.
Your book is of which year? Which year?
My lords, it's 2023. 2023.
Pass it on.
If I may, my lord. There is a judgment, my lord, Reva Electric. My lord.
Just a minute. It will be referred to, it will be appropriate to refer. Paragraph. Five. To 12. Are extracted below. Next one. From the above, it is seen that insofar as subsection 6A of the Arbitration and Conciliation Act 1996 is concerned, comma, the said provision came to be omitted,
My lords, may I clear this fact?
came to be omitted by Act 33 of 2019, which came into force on 30/8/2019. Full stop. Therefore, on and from the said date, comma, subsection 6A stands omitted.
My lords, there is a mistake regarding that. May I clear that? There is a mistake in the Bear Act. There are two sets of Bear Act. There is a mistake.
You are referring to Bear Act. I am not referring to Bear Act. I am citing the Supreme Court judgment. Supreme Court says that it has been omitted. You are disputing the Supreme Court judgment.
No, I am not, my lords, I am not.
I am quoting the Supreme Court judgment. It is, I'll quote here, you will find it in the order. I am quoting it. Therefore, comma. Para 7 of the said judgment makes it makes the interpretation of section 16 within bracket 1 of the Arbitration and Conciliation Act to the effect that the arbitral tribunal will have competence to make to rule on its own jurisdiction. Full stop. Next paragraph. The learned counsel for the A2. The learned counsel for the petitioner has referred to the reply by the petitioner. Oh, sorry, by the respondent. Where is that? Where is that reply?
Clear page number, my lord. The affidavit, my lord, that they have filed,
Page.
the last page, my lord, 63.
Has referred to the reply dated 2/7/2021. Within bracket annexure K to the affidavit in opposition filed by the respondent. Against the notice under section 11 of the Arbitration and Conciliation Act for appointment of arbitrator dated 10/5/2021. The two paragraphs of the said letter is quoted below, page 63. Next paragraph, therefore, comma, it appears that the
My lord,
petitioner, or the respondent, had not objected to the appointment of arbitrator as such. The only objection was for appointment of arbitrator at Guwahati.
my lord, with your lordship's permission, may I make a submission with regard to this query?
No, you see, you complete your argument. When I'm in course of dictation, I can't take up arguments. He gave that argument and then I started the dictation. You did not say that you will reply to that. Half, what you call, halfway the, what you call the dictation, you can't start arguing again. Next paragraph. Insofar as the partnership agreement is concerned, comma, without commenting on whether the stand of the respondent is right or wrong, that the purpose for which the arbitration, purpose for which the partnership was open is not live. As the tenure of the agreement, principal agreement between the petitioner and the Dr. Lal Path Lab has expired, yet unless a partnership is brought to its logical conclusion, merely because the original agreement between the petitioner and Dr. Lal Path Lab Dr. Lal Path Private Limited had lapsed, would not make the arbitration agreement infructuous. To stop. As per the stand taken by the petitioner, some assets were created in the said partnership business. And according to the petitioner, the assets of the partnership firm has been retained by the respondent. Therefore, even for the purpose of dispute which arise out of the partnership assets, or the court would be inclined to hold that the arbitration clause would be valid and binding and would constitute a separate agreement which can be enforced, even if the submission of the learned counsel for the respondent is accepted, that the partnership itself has come to an end. Yes, now what do you wanted to say?
With regard to that very statement that he has made that we had accepted, because I had not, even if I have said that at the position that I was not unable to come to Guwahati, but since I have filed an application and I have raising pertinent questions below, so I am not precluded from only because of that statement of mine. I cannot be precluded from raising these questions, and the lordships have to decide. That's what I'm saying.
Okay. Are you aware of the principle that any pleading filed before the High Court, when supported by an affidavit, becomes an evidence?
Yes, I know.
You are aware of it.
I'm aware.
How do you come out of your evidence? In evidence, you know the principle of admission.
Yes, sir.
How do you come out of that admission?
It is not an admission as such, my lord. I may have been ill-advised at that point of time. So
Then perhaps you'll have to find out
Since-
one of my judgments, where I have clearly indicated that pleading before the High Court, it constitutes an evidence.
that is not disputed. That is
Ah.
not disputed.
And that is why if the pleadings are bad means in the sense it's not supported by an affidavit, the pleadings can be thrown out. Correct. We can also proceed if the inconsistent pleading is made. We can take it that it amounts to misleading, and the court can also always take a view that fraud is played upon the court.
No, I'm not misleading in any such.
No, I'm just saying. You'll have to just find out from one of my judgments where I've clearly indicated
I will be
Of-
enlightened.
of all these things. Accordingly. Next one. Justo. Next one, therefore, the insofar as the case of Magic Eye Developers Private Limited within bracket Supra, cited by the learned counsel for the respondent is concerned, the court finds that the said decision would not be applicable in the present case in hand, for the simple reason that in the present case in hand, there isn't a registered partnership agreement which contains an arbitration clause. And therefore, the court has arrived at the conclusion that notwithstanding whether the tenure of the agreement has expired or not, but for the purpose of determination of dispute intersect between the partners, the arbitration clause in the agreement would survive. Next, accordingly, the objection made in respect of made against the appointment of arbitrator is rejected. Next paragraph, this court is inclined to allow this application for appointment of arbitrator to adjudicate the dispute between the petitioner and the respondent arising out of the deed of partnership. Registered deed of partnership dated 7/4/2010, which contains arbitration clause. At clause 13 thereof. Next, according to the. I have a list of arbitrators. I don't have it right now. I'll name a district judge who's residing in the nearby vicinity and appoint him as arbitrator. Because I need tomorrow morning at 10:30 be here. I just ask the names if it is. List as an arbitrator. Arbitrator list. At 10:30 be here in the morning.
10:15.
At 10:15, yes. Be here. I'll just tell the names if it is agreeable to you. Okay. All right, boss. The citation you are wanting, you can look at that citation. I give you the SCC. The name of the parties is. It's a decision here. Weatherford. WEATHER, Weatherford. Oil Tool Middle East Limited versus Baker Hughes, HUGHES, Singapore PTE. Within bracket 2022, 0 Supreme SC 1082. SCC citation you have to find out whether Weatherford Oil Tool Middle East Limited.
I'll go through that.
Yes,
Lordship, item 12 can be on Thursday, Lordship. 3rd August. Item
Thursday, I
12,
don't think it will come.
division benches.
It's a division bench on that day.
Lordship,
We'll fix a date. Let the courtmaster fix a date.
Lordship,
14/8,
8, Tuesday
14/8.
before 15 August. So can it be on 8,
Election petition, no?
10?
I have a lot of
10, 8?
election matters and all those on the Tuesdays and Thursdays. I hardly have time
Lordship,
these days.
then 14, 8.
Unna,
14/8, 12.